It cannot wait.
Why? What is urgency?
The competent authority under the Housing Board, West Bengal Apartment Ownership Act, unbelievable actions at his instance, seeking to, appoint his own, persons to conduct an election for, this
When is the election scheduled?
25th. And your lordship will be surprised to hear something, I'll be making it very clear.
Hand over.
My lord, may I mention?
Leave will be
Leave is granted.
Tomorrow. Great.
Yes, Saudhikari.
My lord, leave was granted and it was in the list yesterday. My lord, I am in nursing home. My bank account has been frozen, current bank account, without due process of law, without notice. My lord, can it be taken up any day next week, Monday, at the top? My lord, I have served notice and come back.
Not at the top, mention on Monday, I'll consider.
My lord, actually, I have a expenditure of more than 35 lakhs per month. Electric bills are due. I cannot.
Monday means, yes, come back on Monday and mention.
My lord.
If I feel I'll upgrade, I'll upgrade. If I can.
My lord, under compelling circumstances, I'm troubling your lordship to file this matter and move it urgently today, my lord. The matter pertaining to the respondent bank without issuing this notice under section 13(4) or without serving us the order under section 14 has directed us to vacate the property today. And
when was the direction given?
My lord, 19 June, we received it day before yesterday, my lord. The letter is dated 19 June and we received it day before yesterday.
Hand over tomorrow.
My lord, they have given it today, my lord.
Today not possible.
And then tomorrow, my lord, at top, my lord, if my lord be pleased.
Tomorrow in the morning, very well, at the top. Tomorrow.
Grateful, lordship. Grateful.
Short service, upon the respondents. Short service upon the respondent.
My lord, I have the similar.
Case, of course.
Call on the next one. Call on the list.
May I have lordships kindly, my lord. With regard to item number 202, my lord, it's a little bit of urgent, my lord. Auction notice has been issued on this 26th day.
No, not now. Call on the next.
Diplo.
Do we mention item number 1 for release?
Release. I don't have determination or what?
No, lordship, this is order passed by Justice Moshmi Bhattacharya.
Since the present review application has been filed in connection with an order passed by the Honorable Justice Moshmi Bhattacharya, let the matter stand released from my list and with liberty to the parties to mention for inclusion before the said bench.
Grateful.
Thank
you.
Excuse me.
Item 2 for release.
Lordship, for the respondent.
I'm Victor for the petitioner, my lord. Unfortunately, we have filed in the wrong determination, my lord.
Wrong determination? What is this about?
Service matter.
Service matter is under groups.
Learned counsel for the parties point out rightly that the matter pertains to a service dispute. Full stop as such, the matter is released from my list due to lack of determination with liberty to the parties to mention for inclusion before the appropriate bench.
Grateful, lordship.
Top item 3 and 4.
Which one should I take up first? Mr. Doctor?
My lord, I am in 4.
4, very well. So you are in?
I am respondent number 3 in both of them.
And you are also in both of the matters?
I'm both the matters for State Bank of India, respondent number 1.
Right.
So, we both are, my lord, financial institutions.
Both are financial. Right.
My lord, I was for the intervener.
You are for the intervener. Yes, yes, Mr. Pandit.
Not, let them do the case, my lord, if required.
Right.
My lord, the respondent numbers 4 to 12, my lord, they were the borrowers, my lord, of from SBI.
Yes.
Which matter is taking up first, 3 or 4?
This is 4 probably.
4.
I'm in 4.
3 who is appearing?
3, Mr. Nimesh Mishra was appearing for the petition.
Pardon? Mr. Mishra is appearing. She is not there? So I'll hear Mr. Datta first then. Yes, very well. Yes, Mr. Datta.
Now, my lord, the section 19 proceeding under the RDB Act, proceeding was initiated. Then, my lord, the decree was passed in favor of the State Bank of India.
decree put into execution. At that stage, there was a settlement. A compromise decree was passed, and thereafter, the decree was partially acted upon. Now, how the decree was partially acted upon, so far as this property is concerned, 25 Rakhal Das RD Road, there were 4 owners of that. 2 of the owners, they undivided mortgage, 1/4 of their respective shares in favor of the bank. Now, in terms of the compromise order, certain payments were made. So far as the petitioner in item number 3 is concerned, his mortgage deed was, title deeds were released. I had sponsored for payment of the first installment, and the property was mortgaged in my favor. Thereafter, certain disputes arose for which the later part or the balance part of the compromise decree could not be executed. Therefore, the bank goes before the recovery officer and says that you recall it so that I can get back my property. The recovery officer had rejected the application on 14th of September 2014. I'm sorry, 2015. Then, recovery officer, pursuant to another application, on 23rd of December 2022, attached the entire property. And finally, the recovery officer, had reviewed the order passed by his predecessor in office as the recovery officer.
They were recalling that
that one.
transaction, yes.
And now, pursuant to that, sale notice, etc., has been issued. Therefore, we are before my lord. Now, kindly, have
So
a.
did you challenge the recall order of the next recovery officer?
Here, it is under challenge.
Very well.
Now, first have a look to the compromise order
Yes.
at page 50, or the compromise certificate, as they call. This OA coming so and so date, in presence of the Learned Counsel for the bank, it is ordered that the defendant jointly and severally to pay to the applicant bank a sum of rupees 10 crores, 40 lakhs, etc., being the compromised amount in lieu of 13 crores, 92 lakhs, such and such. The compromised amount is to be paid strictly as per the terms specified in the annexure to the compromise decree attached to the certificate, the recovery officer, to ensure that no interest to be recovered from the CD if the total payment is recovered within 12 months. The failure to pay the compromised amount as per the terms laid down in the said annexure shall entitle the CHB, and accordingly the CHB is allowed to claim the entire amount of 13.92 crores along with interest, etc. Now, what happens thereafter, pursuant to an arrangement, I pay a sum of rupees 1 crore and odd, which, we have the documents, your lordship will find from pages. Please have a look to page 68 first.
There was no schedule of the tranches.
That your lordship will find at page 57.
57.
Please have a look at page 57. This is recorded in the order of the recovery officer. I'm sorry, it's not page 57.
No, not 57 probably.
I'm sorry.
Somewhere else. But in the certificate, there was no segregation.
57, it's 77. I'm so sorry.
77. In the certificate, there was no segregation.
It was not mentioned, but it was in an annexure.
Very well.
This your lordship will get, noted at page 77 in the first order, Kindly take at page 77.
Yes.
But may I read from a middle of a sentence at the top of that page 77?
Yes.
The mortgage properties would be released in a phase-wise manner. So and so, so and so. In the first phase, your lordship will find rupees 0.05 crore, rupees 1 crore already paid. Now, I had paid this 1 crore. I'll demonstrate that. This is to be released immediately on acceptance of the offer. What is to be released is 25 Rakhaldas, RD Road, etc. Then next is 0.77 crores, 4 months from 1. Then 4.05 crores, 4 months from 2. and 4.53 crores, 4 months from 3.
So C is extremely important for you. Next clause
Yes. Yes,
after the chart.
yes. But this is his finding. This is his finding. So
Acha, acha. Oh, this was recalled. Subject.
yes.
Acha, acha.
Now, my lord, how I had paid this 1 crore, this my lord will find, my lord, at page 68.
$68, yes.
Well, first, my lord, I write to Sean Automobiles, who is the petitioner in item number 3. Please take me the second paragraph. As requested by you, we are enclosing herewith a check of rupees 1 crore in favor of the authorized officer SBI, so and so account, no lien account. Please acknowledge the receipt. Well, this is forwarded to at the bottom, my lord, in handwriting. Your lordship will find to the Assistant General Manager, State Bank of India. The check is on the next page. Drawn in favor of, my lord, authorized officer, such and such.
This was that initial 1 crore.
Initial 1 crore.
Then this order had not been passed by the
It's before the order. That is why, my lord, on receipt of 0.5 crore, they are going to release the property.
Was this order acted upon?
Yes, yes.
That 0.5 was paid subsequently.
Yes, 0.5 paid, title deed released in favor of the petitioner. Yes. Please have a look to the next page. That is page 70 and then 71. Yes. Please take 71.
71, yes.
Yes. Here, my lord, it is recorded. Petitioner in writ petition number 3, I mean, in the item number 3, writes to my client, I am glad to inform you that the amount of rupees 1.05 only given by you to Sean Automobiles has been utilized for settling the account of State Bank of India in the OTS proposal. In pursuance of the order dated so and so, passed by so and so, the original title deed, number, etc., in respect of 1/4 share of premises number, etc., together with so and so has been released by the bank and handed over to me. In pursuance of the agreed terms of the MOU,
Yes.
dated 15 December 2010, I am forwarding herewith the above mentioned title deeds. Enclosure, your lordship finds at the bottom, original title deed of 1/4 share. Thereafter, my lord, this Sean Automobiles, my lord, to secure, my lord, the payment of rupees 1.05 crore, my lord, mortgages this property in my favor by, my lord, handing over the title deeds. My lord, the legal effect, my lord, as your lordship would kindly appreciate. My lord, today, my lord, I have subrogated to the interest of the bank in respect of 1/4 share in this premises. Now, my lord, after all these happens, my lord, the bank now goes before the recovery officer, which is at page 74. Now, kindly have a look to my lord, page 74. Page 74, my lord, the third paragraph. What are the prayers? Learned advocate for the certificate holder bank, so and so, prays for a short time. The CHB has filed an application praying for the following reliefs. One is modify the certificate of 18th of March 2014. B, call upon the respondents to pay a sum of rupees 12 crores and odd. C is direct attachment and sale of the mortgage properties mentioned in para 10 and 11. Cost further orders. But these were the prayers. My lord, instead of, my lord, taking your lordship in its entirety, please turn to the next page, page number 75. My lord, the fourth paragraph on the joint prayer.
Yes.
Of the parties, a compromise decree was passed by the learned tribunal on 19/3/2014, and consequently the instant recovery proceeding number, etc., has been initiated. Now, my lord, kindly turn over the next page, the paragraph starting with initially, page 76.
Yes.
Initially, when the order dated 12/6/2015 appointing joint receivers were passed, the CHB has not clearly detailed the difference between the released and the mortgage property. The CD number 2 was personally present on 12/6/2015 and attempted to explain the situation, but the status of the properties detailed in para 10 and 11 of the said application was not very clear. I had directed to attach all the properties by appointing joint receivers and had directed that the parties to exchange affidavits to ensure that the public money is not drained. The CDs have filed their affidavit in opposition, etc. with the defense, which runs as follows. Milord, kindly skip over Milord A, B. B, Milord, I have placed. C, your lordship has been pleased to draw the attention, draw my attention is C.
Yes.
According to the CDs, once a property is released, the same cannot be treated and or alleged to as a secured property, asset and or mortgage. The rest, Milord, I don't read. Then kindly take, Milord, but the other factual parts, Milord, may be skipped over for the time being. Please take, Milord, page 81.
Was this given effect to any of the clauses, any of the tranches given effect to after this order?
First and second.
Probably not.
First and second.
First annexure. No, everything was previous
Milord,
to this.
page,
This
no.
order was dated, page 75 order was dated sometime in, it was
Milord,
14th
19th of March 2014 is the compromise order.
compromise order. In terms of that, 1.5 was paid by 2 tranches.
Yes.
But 14th of September 2015, that is the order of the first order of the tribunal.
Right.
After that, nothing happened in terms of this.
No.
Very well.
Milord, insofar as, Milord, the payment, the one with which I am concerned, Milord, in
25.
2010, Milord, there was an agreement between me and Sean Automobiles. 2010.
Pursuant to that, you had paid.
Yes. 2011, Milord, I pay. 2014 is the compromise. Thereafter, Milord, this order of 19th of March 2014 passed.
Yes.
And thereafter, the balance 5 lakh paid and Milord, title deeds handed over.
Right.
Now, Milord, I was at page 81. Please take this third paragraph over there.
Yes, third paragraph.
I find that the CHB has, however, has not denied or questioned the existence of the said contract between the CDs with the said city staff, that is my client, and the said knowledge. The bank says that any charge created by the CDs in favor of City Star and the knowledge is subject to the charge of the bank and cannot be created without liquidating the dues of the bank in full in terms of the compromise settlement. It is the contention of the CHB that it is entitled to reliefs as prayed for in the application and demand payment of the entire dues because of the failure on the part of the CDs to comply with the terms of settlement and consequential cancellation of settlement. The CHB prays for orders as prayed for in the application to be granted. Now kindly take my page 82, his decision at the bottom. But that was the defense of the bank, which I have read, Milord, from page 81.
Right.
Considering the documents placed on record and the pleadings filed by the parties, and after hearing the parties, I decide as follows. In terms of the settlement letter, which is admitted by both the CHB and CDs, that the loan account was settled at an amount of 10.10 crores payable within 12 months as per the schedule details therein. It is also not in dispute that the properties which were securities of the CHB has been released by receiving payment. But this is admitted. In
shall be released, it was said. It is recorded shall be released.
I'm so sorry. Yes.
Yes.
In installments towards settlement amount detailed in the said letter of 17th December. Again, both the CHB and CD have unequivocally admitted that the CDs have paid an amount of rupees 1.05 crores with the property situated at such and such has been released by the CHB in favor of CDs. And the original title deeds have been returned. Further, by receiving rupees 77 lakhs, the CHB has also released properties of 177B and C SP Mukherjee Road, and the original title deeds have been returned by CHB and CDs. However, the last 2 installments comprising of so-and-so has not been paid, and 2 properties, that is so-and-so remain mortgaged securities with the CHB. Considering the defense of CDs that the property at 25 Rakhal Das Addi Road was released upon payment of rupees 1.05 crores, which the CDs have borrowed from City Star, and after the release of the original title deeds, the same was delivered to City Star and the said property was mortgaged with it. The CHB has not disputed or denied the arrangement between the City Star and CDs. In view of the situation, it would be unjust, unequitable on my part, to hold that even after receiving the amount of rupees 1.05 crores and releasing the said property at 25 Rakhaldas Agdi Road, Kolkata, the said property would remain mortgaged with CHB. There would be no impediment and or legal restraint in attaching the property at 25 Rakhaldas Agdi Road in the event after release of the property still remained unencumbered assets of CD. This is what, Millard, it has been found. The CHB has not denied that denied and disputed the contract that was entered between the CDs and the City Star regarding the amount borrowed by the CDs and the City Star. All that the CHB has stated that since it is not party to the contract between the CDs and City Star, the same is not binding upon it. Such contention of CHB is correct, but the fact remains that after release of the property at so-and-so, the same was equitably mortgaged by the CDs in favor of City Star. The relationship between CD and City Star is of a mortgagor and mortgagee respectively, where there exists a debt. Intention to create mortgage is also apparent, established by way of documentary and circumstantial evidence, and the original title deed is being held by City Star. The CHB has not denied that the said City Star is holding the original document. In view of such situation, the said City Star is the secured creditor to the said CDs and the property is mortgaged with the said City Star. The said City Star thus holds paramount charge holder, which in the given situation can neither be denied nor disputed. All the ingredients as postulated in section 858F of the TP Act appears to have been complied with. In such a circumstance, it would be unlawful, unjust to attach the property at such and such and allow the CHB to benefit itself by receiving the amount of rupees 1.05 crores at one instance, and at the other instance to enforce the released property. I have specifically inquired from CHB whether they are willing to refund the amount received towards the release of the said property situated and so, when the CHB has not advanced any comment. Similar is this, Millard, I don't trouble your lordship with B. Now, please see E at page 85.
So, Dr. You have got a very bad case.
Yes. Let us see, Millard. I'll try to, Millard.
Yes, definitely convince me otherwise.
Yes. Then, Millard, at E, page 85E, in the above circumstances as discussed above, I am of the opinion that the order of attachment passed on so-and-so in respect of so-and-so be withdrawn and set aside with immediate effect. Then kindly take K at page 86.
86, yes.
The properties at so-and-so against which title deeds have been handed over to the CDs are released with immediate effect, and the said properties are free from all charge, etc. So, my lord, everything over, attachment, my lord, undone, documents released. Thereafter, my lord, this order was never challenged by the bank. Subsequently, my lord, they again go before the recovery officer, my lord, and my lord, make an application. Where there was a warrant of attachment, then there was an order of attachment of the property. Then, my lord, I was directed to submit documents of compliance, and finally, kindly have a look to the order which is under challenge. That is page 124. With the orders in between, my lord, I don't trouble your lordship.
Yes, right. Unless they have a relevant, direct relevant bearing, then.
But one part, my lord, before going to that. Now, why this application once again?
Pardon, I couldn't get.
After, my lord, dismissal of the first application,
yes,
whatever may be its merit, where bank having not challenged that order.
Yes, that is a very good point. Yes.
And thereafter, they filed a second application.
Was it for recall of that order specifically?
No. The prayer was the same, but the ground was different.
Very well, the constructive res judicata principle may apply.
Yes.
Anyway, let us see this.
And finally, the order has been reviewed. Yes. Finally, the order has been reviewed. On that also, I have some submissions to make whether, my lord, the review can be made.
Yes.
Now,
definitely.
Before going to the other order, please have a look to the order of 14th of November 22 at page 89. Now, what is the reason for going back to the recovery officer? Your lordship will find word in the bottom of that page in bold.
Yes.
Or 4 lines before that, he also prays for attachment of the released properties as per the terms and conditions of the compromise sanction letter mentioned above, wherein it has been clearly mentioned that in case the compromise amount was not paid as per the above arrangements, from the date of communication of sanction, all rights and remedies available to the bank prior to the compromise settlement will be available to the bank. Now, this is the ground on which, Millard, they go back before the tribunal. But, Millard, on facts, Millard, there was no dispute that everything was released, money was paid, and again, it was remortgaged. I won't say it was a fresh mortgage in my favor. This your lordship will find reiteration at page 91 also. But fifth line from the
Yes.
top, again, Millard, the same quoted portion. After the quoted portion, in
Yes.
other words, in case of default, the compromise settlement will become infructuous and CHB will be entitled to proceed against the securities, the right which was available prior to the said compromise. Hence, under Rule 87 of the second schedule of the Income Tax Act, the order passed by the then recovery officer, video order number, etc., is hereby reviewed and modified to the extent that the properties mentioned at serial numbers 1 and 2 be attached as the personal property of the certificate debtor. Then we'll have one paragraph thereafter, let orders of attachment of such and such be issued. But-
So this was the occasion of reopening that issue.
This is the occasion, Millard, where Millard, there was a question, Millard, which was raised that it was beyond the jurisdiction of the recovery officer. That your lordship would find, Millard, page 90, fourth line from top. But this is our contention.
Yes, yes, yes.
But then there are the follow-up orders, Millard. Please only note down the page numbers, Millard. I don't think, Millard,
Or that
those-
previous order was passed by the presiding officer.
the certificate order, the first one.
The
But
first order on which you rely.
The procedure is, Millard,
Yes.
once the certificate is issued, thereafter it goes within the domain of the recovery officer.
Recovery officer, yes.
Who executes the decree or the
Right.
certificate.
Now, the previous order which you placed before me, that was also before by the recovery officer.
Yes,
Must be, yes.
yes, yes.
Very.
Therefore, today, Millard, we stand at a situation where, Millard, the recovery officer who executes the decree of a judicial officer, Millard, is effectively modifying or trying to recall a decree passed by the judicial officer. That is the presiding.
Decree, you mean the compromise certificate ultimately.
Now, compromise,
Compromise certificate is your worst footing actually.
Millard, may I say this,
In
Millard?
the sense, if it is interpreted properly, I mean, in plain English even, then the entire date is, I mean, it's embroiled together.
Could I say this, Millard, as your lordships have held, Millard, a compromise decree is both a contract and a command of court.
True, absolutely.
Therefore,
Hmm.
therefore, today, Millard, the contract having matured into a command of the court,
Hmm.
Millard, it can be recalled, reviewed, set aside, whatever it is, Millard,
Only by that code.
only by that court.
No,
or
even
higher of court.
Yes, even if it is not reviewed, Mr. Dotto,
Yes,
what is the merit of your case? Even if it is not reviewed,
yes,
the first few taken by the recovery officer, if it was wrong,
yes,
can't the recovery officer reopen that?
yes.
Are you on that also, that he cannot reopen his own order?
Millard, fundamentally, Millard, my first point is, Millard, a recovery officer, whether
Definitely.
he has a power of review or not, if he ultimately, Millard, passes any order contrary to the compromise
Cannot.
certificate at page
Definitely.
50, then, Millard, it is completely without jurisdiction.
Definitely. Definitely. It's an execution proceeding.
Number one. Number two, Millard, here facts are admitted. The admitted fact is relevant for our purposes.
What was your prediction before coming to court, Mr. Dotto, regarding the fate of this one?
Uh,
Tell me that after I pass my order.
Millard,
No, don't.
I'll tell you, Lordship, one thing. We're digressing for a moment. Millard, I have never been able to keep myself, Millard, away from the client's interest.
No, you should not also. But you are sufficiently aloof from that interest to get a senior account, Mr. Datta. And you deserve that also.
But I do not know Milord, whether I really
definitely you
deserve that or not, because
Definitely you deserve.
the basic Milord
You are
training,
there for the client to present the case of the client. Absolutely. Why not?
no, not only to present Milord, the basic Milord training which we had
Yes.
is not to identify ourselves with the clients.
But you have to empathize up to a point. Definitely, Mr. Datta. Otherwise, you are machines.
Yes, yes.
Otherwise, you are machines. Then you feed data into a computer and the computer will pass judgments. That day is coming also, but
Yes, artificial
till that does not
intelligence.
come, yes. Let it
Artificial
remain
intelligence.
artificial. The EQ is difficult to incorporate in the chip. For that, we have to know so much of the functioning of the body that probably in a million years we won't be knowing that, because we are evolving also. In a million years, we will be evolving further. Anyway, let us not go into that.
Yes. Now, Milord, my first submission I have made.
Yes.
But the second submission is, Milord, mortgage, as your lordships know, that Milord, it is a security for payment of money. And there has to be a debt.
Hmm.
Today, Milord, the altered situation is that between me and the Sean Automobiles, Milord, there is a debt, there is a relationship, and there is a security. How is the security made? The security is made by way of deposit of title deeds.
Sean is the certificate debtor.
Sean is certificate debtor and petitioner in the other matter.
Yes. Very good.
Therefore, Milord, I am the mortgagee.
Between you and Sean, yes, definitely. You are the one.
Now, so far as Milord, the bank is concerned, Milord, bank, in order to have Milord any rights surviving in respect of the mortgage, Milord has to hold the title deeds, which it doesn't have. Milord, there could have been a situation where I could have been a puny mortgagee.
Yes.
In order to be a puny mortgagee, Milord, there has to be a parent mortgage surviving.
You
Therefore,
have no connection with the bank directly.
I don't have any.
No.
Therefore, Milord, what is the legal effect? The legal effect is that, Milord, I subrogate as a mortgagee in place of the bank. Or, Milord, the substitution of mortgagee takes place.
Insofar as 25, that property.
That property is concerned.
Obviously, yes. But what is the occasion of your substituting the bank? You never had any connection with the bank. You may not have, but you may still substitute. But you are not substituting in the place of the bank.
No.
The relationship between the bank and the certificate debtor remains, Mr. Datta. You don't come in at that within that picture at
Yes,
all.
Milord, may I say this, Milord?
Yes.
A mortgager
Between you and Sean, yes.
But
I'm
was
sorry.
on a
Yes.
different footing. Milord.
Please.
A mortgager is never substituted.
No.
Substitution takes place in respect of mortgages. One mortgage comes to an end, another mortgage comes into being. That is a situation where, Milord, a subrogation takes place.
Yes.
Or a substitution takes place. Therefore, Milord, I need not have any relationship with the prior mortgage
All right.
or the prior mortgagee. Milord, that would have been a situation, Milord. If that had been a situation, then Milord, I would have been a puny mortgagee.
All right.
Or my mortgage would have been a puny mortgage.
So, for it to be a puny mortgage, you had to have a relationship with the bank.
Milord,
Some
may
relationship.
I put this in this way? To be a puny mortgage, Milord, there has to be a primary mortgage.
Yes. Yes.
Now, today, if I am relegated to the puny mortgagee or the puny mortgage, then the primary mortgage has to survive, which has not survived, which is over.
Very well.
And my lord, as your lordships know, my lord, the mortgagee's interest
Hmm.
or the remedy
Hmm.
is either by foreclosure or by sale.
Yes.
That cannot happen so far as the bank is concerned.
Hmm.
Now, the ancillary question which may arise is that because of this compromise or because of that bold portion in the
Yes.
review order, what interest of the bank survives today? Well, my very respectful submission would be, my lord, whatever interest in respect of this property can survives in favor of the bank, it can never be an mortgagee's interest in the property anymore.
So how will you label that interest then?
Well,
Suppose
it could be in one sense where it could be a banker's lien.
all right. Very well. There are other options.
There are other options.
Jural options.
Yes.
Very well.
There may be other securities also. Therefore, my lord, finally, my lord, even if, my lord, going by that bold portion, my lord, the recovery officer, assuming to have any jurisdiction, my lord, ought to have applied in his mind as to what is the interest surviving. Do the mortgagee's interest, recur? In the case there is a failure of the compromise, my lord, in my very humble understanding, my lord, it does not recur.
Hmm.
Well, this is, my lord, the outlines of my submissions.
Hmm.
Now, my lord, going by, my lord, the statute, my lord, please have a look to, my lord, the Recovery of Debts Act.
Securitization-টা আছে, কিন্তু এতে কি recovery of debts আছে? শুধু securitization আছে। Thank you. Recovery of debts টা একটা আলাদা আনি, একটা বড় বই আছে যেটা সবকটা আছে, সার্ফেসি ফারফেসি বাড়িতে আছে ওটা। Anyway, তুমি এটা আলাদা আনিয়ে নাও। Yes, sir.
My lord, a presiding officer is defined under section 2JA.
Yes.
Means a presiding officer
4-1.
appointed under section 4. Then, my lord, in section 4, composition of the tribunal, a tribunal shall consist of one person only, hereafter referred to as the presiding officer, to be appointed by notification by the central government. Notwithstanding anything contained in subsection 1, the central government may authorize the presiding officer of one tribunal to discharge the functions of the presiding officer of another tribunal. That we are not concerned with that. Now, who is a recovery officer? Section 2K read with section 7. Recovery officer means a recovery officer appointed by the central government for each tribunal under subsection 1 of section 7. Now, please have a look to below section 7. Recovery officer is a staff of a tribunal. The central government shall provide the tribunal with one or more recovery officers and such officers and employees as that government may think fit. The recovery officer and the other officers and employees of the tribunal shall discharge their functions under the general superintendence of the presiding officer.
He's somewhere in between a bailiff and an executing court. Somewhere in between. More towards a bailiff probably as per this.
Yes.
But he has certain powers akin to
No
executive court
doubt
also.
about that. He has powers. No doubt about that. Then, my lord, section 19 is, my lord, what is to be done, etc. Now, without, my lord, troubling your lordship with the section 19 in its entirety, my lord, section 90 also contemplates a compromise order. Please have a look to, my lord, section 19, subsection 20, capital A.
Yes.
Where it is proved to the satisfaction of the tribunal that the claim of the applicant has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant has repaid or agreed to repay the claim of the applicant, the tribunal shall pass orders recording agreement, compromise, or satisfaction of the claim. So this is the power of the tribunal also to pass compromise orders. Milord, why I am drawing your lordship's attention that, Milord, the legislature thought it fit that to empower the tribunal to pass a compromise order, there has to be a specific provision for that. That is why this has been incorporated by way of an amendment in 2013. Then please take, Milord, 22.
22 years.
I'm sorry, and section 19, subsection 22.
Yes, yes, that time.
The presiding officer shall issue a certificate under the signature on the basis of the order of the tribunal to the recovery officer to recover the amount of debt specified in the certificate. Then comes, Milord, 22A. 22A টা আমার বলতে নেই। আছে? Thank you. Yes. We'll kindly see whether 22 is there.
It
or not.
is there,
In my
luckily.
book, it's not.
I understood. Yes.
Any recovery certificate issued by the presiding officer under subsection 22 shall be deemed to be a decree or order of the court for the purpose of initiation of winding up proceedings against a company or the Companies Act, Limited Liability Partnership, registered under the so-and-so Act, or insolvency proceeding against any individual or partnership firm under any law for the time being force. Therefore, Milord, a recovery certificate is also for certain purposes, Milord, is considered to be a decree. Then kindly take, Milord, sorry, I'm so sorry. Then please, Milord, have a look to, Milord, section 22, subsection 3. This is a judicial proceeding.
Yes.
Any proceeding before the tribunal or the appellate tribunal shall be deemed to be a judicial proceeding within the meaning of such and such. But after all this, Milord, now the recovery officer's jurisdiction starts from section 25.
Is this on the proposition that recovery officer cannot review? Definitely he cannot. I mean, but even
I leave it.
no, these sections are relevant. Definitely, yes.
Milord, section 25.
Yes.
Of recovery. Attachment. Arrest. Appointment of receiver.
Do you say the recovery officer does not have power to review his own order? Do you say that also?
Yes. I'll tell you, Lordship, why. Because the procedural law to this, or the rules, empowers only the tribunal to review its order.
Recovery officer is not the tribunal.
No.
He's a recovery, not agent. I mean, recovery officer is a recovery officer, basically. Yes. Very well.
And please have a look to, Milord, section 26 now.
26, yes.
26, subsection 2. The power is with the presiding officer. Notwithstanding the issue of certificate to a recovery officer, the presiding officer shall have the power to withdraw the certificate or correct any clerical or arithmetical mistake in the certificate by sending an intimation to the recovery officer. So, Milord, only to this extent of withdrawal, and Milord, the other part is in the nature of 152. But this again, Milord, is conferred by the statute with the presiding officer.
Yes. Yes.
Milord, this is, Milord, the confines of the statute, where so far as, Milord, the powers of the recovery officer is concerned. And so far as review is concerned, please have a look at section 22, 2E, read with rule 5A.
Yes, rule 5A.
Now, please have a look at the rule 5A of the Debt Recovery Tribunal Procedure Rules 1993.
So only mistake or error apparent on the face of the record. One of the three criteria of variable. That too by a presiding officer.
Presiding officer.
And here nobody has asked for a review of the certificate, compromise certificate basically. That review has not been asked by anybody.
No.
On the basis of that certificate, one order was passed initially by recovery officer. Virtually that has been recalled now or reviewed or whatever. Very well.
Now, my lord, I will be honest to the court. We can draw a power of review or presume a power of review of the recovery officer. How? Through the Income Tax Act. Why I say this, my lord? Your lordship will find, my lord, from section 28, subsection 5 of the Act.
Of this act.
This Act. But in the powers mode of recovery,
Achha.
হ্যাঁ সেটাই 28 subsection 5, the recovery officer may recover any amount due from the defendant by distrent and sale of his movable property in the manner laid down in the third schedule of the Income Tax Act. Now, my lord, the Income Tax Act, and my lord, I'm sorry, my lord, yes. Schedule 2 টা কোথায় না দেখলাম? Yes. Then kindly take note section 29. The provisions of the second and the third schedule of the Income Tax Act and the so and so, as in force from time to time, shall, as far as possible, apply with necessary modification, as if the said provisions and the rules refer to the amount of debt due under this Act instead of to the Income Tax Act. But I lay emphasis on the expressions or the phrase as far as possible. Why I say this, my lord? Because there is a power of review on the tax recovery officer, my lord, under the Income Tax Act.
This probably, Mr. Datu, you're on a better footing because of 28.5 language itself.
Yes.
Because it is for a limited in a limited context that it is applied, not in toto.
Yes.
I mean, only debt due may recover by distrent and sale, that will be in the manner laid down in third schedule. So only insofar as that is concerned, this has been given.
Yes.
Now,
Now,
power of review has to be conferred specifically, maybe.
yes. Third schedule, my lord, does not contain any power of review.
Achha. The income tax officer has a power of review under the Act
Second schedule.
in the second schedule,
Second schedule of income
which
tax.
is also applicable to third schedule
Which is
or income tax officer.
income tax laws, my lord, under the
All right.
section 29. Second and third.
Second, yeah, all right. Very well. Very well. Apply with necessary modifications, as if they said.
Yes.
Very well. Yes. Yes. That is a very valid argument you are making.
Yes, therefore, my lord, even if we, my lord, latch on to the power of review.
We have to read it through the focal point of 28.5. 28.5 but relates that act, third schedule, to only discontent sale in recovery of a debt due under this act.
Right.
So that discontent sale, insofar as that is concerned, yes, third schedule applies. And for that purpose, to apply the third schedule, second schedule is also enabled mutatis mutandis. And with a necessary modification that is given extra. I mean,
Yes.
that is also there. So you are on a much valid footing there.
Well, to add to that,
Yes.
is 29 the phrase as far as possible. But I stretch
That is there.
but I stretch it for the recovery officer to the maximum extent
Very well.
and make the entire second schedule applicable as far as possible.
Yes, but then again, necessary modifications comes in.
This is a modification.
That is the extra thing. I mean, from mutatis mutandis, not there in other statutes generally.
But the possibility ends with Rule 5A of the procedural rules. All these brackets are on.
Yes, Mr. Rath. So then also Rule 5A provides that, oh, that's for the presiding officers. Sorry. Yes, very.
But again, assuming, my lord, that a power of review, my lord, can be taken through the Income Tax Act, my lord, that is also, my lord, only confined to mistake apparent from the record.
Yes.
On account of mistake apparent from the face of record.
That is arguable for them. It can be a mistake. It may be a mistake apparent in misinterpreting the certificate.
Subject to Rule 5A.
The rest remains. The rest of your argument remains. Yes.
So, I think that
That's the worst point against you. I mean,
yes, I think
Income
that
tax.
I should be.
No,
honest
thank you
enough
so much for
to-
it.
to
So you justify my earlier comment. Anyway, sir.
Number, so therefore, my lord, my lord, this is the statutory scheme.
Right.
Fundamentally, on, my lord, the basic principle of law, I have already made my submission. Judicial officers' order cannot be reviewed, recalled,
Yes.
modified, tempered, tinkered, whichever is the appropriate expression by an administrative officer.
What is the ratio of the second order? Why is it recalled? There was an error apparent on the face of the
Yes.
record.
According to them, that bold portion was not looked into.
Looked into, yes.
Okay,
But the the impugned order is at page 124.
well, these are all subsequent orders, my lord,
Oh,
because,
acha.
the property has been finally directed to be sold. That is at page 124.
You are challenging all of these.
But my challenge would start from, my lord, in fact, my lord, from page 89.
89, right.
89, 93, then sale notice at 123,
Yes.
123 and 124.
The rest are consequential, basically. Very good.
Now, my lord, on the other aspect, that what is the interest of the bank surviving? In a case of this nature, where, my lord, title deeds have been returned, ওটা আমি বলে দিচ্ছি তারা। What is the interest surviving? Please have a look at one judgment of the Supreme Court of 1983. Copy, 63, I'm sorry. AIR 1963, Supreme Court 1041. But this is in a case of an usufructory mortgage, but please consider, my lord, subject to correction, my lord, this would apply.
এটা টানি না recovery of this. Yes.
My lord, I would, my lord, invite your lordship to apply this principle even in a case of equitable mortgage. My lord, paragraph 4 of this judgment.
Paragraph, yes.
Section 58 of the Transfer of Property Act defines mortgage to be a transfer of an interest in specific movable property for the purpose of securing the payment of money advance or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. It also defines various varieties of mortgage and in clause D defines usufructuary mortgage. Thus, then it is defined after the quoted portion, when the mortgage money is paid by the mortgager to the mortgagee, there does not remain any debt due to the mortgager to the mortgagee, and therefore the mortgage can no longer continue after the mortgage money has been paid. No dispute on that. The transfer of interest represented by the mortgage was for a certain purpose, and that was to secure payment of the money advanced by way of loan. A security cannot exist after the loan had been paid up. If any interest in the property continues to vest in the mortgagee, subsequent to the payment of the mortgage money to him, it would be an interest different from that of a mortgagee's interest. The mortgage,
As you submitted.
yes, as a transfer of an interest in an immovable property for the purpose of securing payment of loan, must come to an end on the payment of the mortgage money. But I will be very respectfully submitting, my lord, this principle would also apply in the facts of this case.
Well,
So, my lord, the bank's interest as a mortgagee, my lord, in respect of this property does not survive anymore. But the only other point, my lord, which I preempt is appeal provision.
appeal?
Appeal. There is a provision for appeal. But I don't think, my lord,
So if it is without jurisdiction, then
Yes,
it could may. Here the appeal provision against a recovery officer is under which section?
this is under section
30.
30.
30.
30.
Thank
These are my submissions.
Thank you. Who is in 4 for the, you are in both matters, both of you.
No, let Mr. Misra conclude. He's in 3.
Right, that will be better.
With the same
Yes.
response.
I think that will be good. You're right.
But may I come back after some time?
Absolutely. Yes. Mr. Mishra, please add only those which have been missed, obviously, I mean.
May I please your lordship, my learned senior representing his cause in item number 4 in today's board is, my lord, my mortgagee. Now, this is an admitted position. The submissions which are already made, my lord, I will not repeat. And my learned senior has developed it far more than what I could have possibly canvassed before, my lord. My lord, however, I am privy to almost all the cause that emerged and originated before the learned recovery officer, because I am the certificate debtor. In item
Sir, can
number
you please take the microphone a bit closer? Yes.
insofar as the City Star is concerned, as my mortgagee, writ petitioner in item number 4, has confined his right only limited to the extent that he is now the secured creditor. Now, nobody's case is that he is not a secured creditor. My lord, the orders are placed before my lord. It is nobody's case. Neither in the first innings before the recovery officer. In fact, repeatedly the recovery officer asked whether the right of City Star is questioned. Nobody questioned. And even
At the first instance.
even in the first instance, my lord, the order is dated 14th of September 2015. Subsequently followed by the order which is impugned in the instant petition. Nobody has questioned the right of City Star. My lord, that is my understanding.
Yes.
In fact, my lord, the case of the bank is essentially that by virtue of the settlement letter, if there is a default, the entire money is payable by the certificate debtor. My lord, that is the position.
But Mr. Mishra, what independent locus standard do you have to move this writ petition against the subsequent orders? I mean, as far as you are concerned, the rest of the debt is not yet paid.
Not been paid. I'm liable.
So you are liable. So what is your locus standard to challenge? You could have
Only
been a
to-
pro forma respondent in his writ petition, which you are probably
Yes, my lord. My only locus standi, if I can say that,
to challenge.
very respectfully, my lord, after the order that was passed on the year 2014 by the learned recovery officer,
Yes.
the cause could not possibly have reopened in guise of a review.
You are not affected either way. As far as your right is right, liability, whatever is concerned, you are within the
Directly
limited
not.
focus of because you don't have a right to
Directly
challenge.
not, because essentially, my lord, it is the right of City Star that gets diluted.
Right.
Very, my lord, I bow down to that aspect. I will only canvass this
I'll take your point in any event because you are a valid pro forma respondent in his writ petition.
in this writ petition.
You are a
simultaneously-
proper party at least.
Yes, my lord, and simultaneously, my writ petition also questions on the jurisdiction part, that the learned recovery officer doesn't have the jurisdiction to reopen the
A
issues.
greater question. I mean,
Yes, my lord.
very well, very well.
And my lord, I understand that my learned friend's case, my lord, submissions have been made by my learned senior, Mr. Dotto, on the power of review. My lord, even for argument's sake, the review power of the learned recovery officer is taken into question. Then Rule 87 of the second schedule on an enlarged right, my lord, is best case for the possibly for the bank. If it's taken into consideration, it is only Rule 87 of the second schedule Income Tax Act. If I may very humbly beseech my lord to kindly see Rule 87 for a while.
Please.
My lord, otherwise under Order 47, the scope of review is otherwise much, much more than 87.
Yes.
Here, if my lord considers Rule 87, which essentially is the provision of which the recovery officer is reopening, is envisaged as follows. Any order passed under this schedule may, after notice to all person interested, may be reviewed by Principal Chief Commissioner or Chief Commissioner or Principal Commissioner or Commissioner, Tax Recovery Officer, possibly this is the authority which we are focused on, or other officer who made the order, or by his successor in office, on account of any mistake apparent from the face of the record, and nothing more. Not sufficient cause, or records which were found subsequently not diligently available. So, my lord, the learned recovery officer has reopened without even holding that there is a mistake on the apparent face of the record. My lord, the petition based on which the entire issue re-emerged is, my lord, if my lord permits me to place that petition, I could not annex in the writ petition, my
Oh,
lord.
achha, achha.
I could not annex in the writ
It
petition.
is annexed to neither of the writ petitions.
Not, my lord, I can understand. I serve a copy because this is their application. If
Yes,
they don't
yes,
dispute,
please.
my lord, this can be taken on record. Kindly consider nobody's case that there is an error on the face of the record, or there is a mistake.
No, review power can be so much exercised also. I mean, as per the
My lord,
language of 87, if you go by 87.
May I advance my argument, my lord, very respectfully in twofold. One, on being invited on the basis of this petition, and two, so moto.
Very well, I get your point.
So, my lord, if we consider this
If it
petition,
was so moto, then it's different. But it's on this application, so has to be confined to that.
Yes, on confined to this.
The expression error apparent on the face of record has
Nowhere,
it has been indicated anywhere. I mean,
nowhere.
argue your worst. Their best.
Argue my worst,
Yes.
they might have. My lord,
Their best paragraph in that regard.
my lord, kindly consider. They might say that kindly see the settlement letter,
No, that is
which
there.
they have canvassed in paragraph number 3.
Very well. That is
And they
there.
may
That is-
say, my lord, that apropos the settlement, which is annexure B to this petition,
Hmm.
there is a clause which is, my lord, if I may indicate, my lord, the settlement letter was placed by my learned senior Mr. Dotto.
Yes, that I've seen, Mr.
That very clause, he says that
That is there.
it reverts back. But my lord will kindly find that in this petition, which is filed by the bank,
Hmm.
my lord, there is no reference to the previous order that is sought to be reviewed.
Oh, acha, acha. They seek a new, no, modify this. Oh, acha, acha. They have sought for a modification of the certificate.
Yes. Not that the same jurisdiction having decided.
Bad bank, bad boy.
I was not that.
And my lord, I raised that point to the learned recovery officer that this is what you cannot possibly do. My lord, will kindly see the order dated 14th of November, which I, if I can place it from my writ petition,
They actually sought for a modification of the certificate, which cannot be granted by.
cannot be granted. And then he proceeds to attach. And once the attachment came, the pro intestes soap application by the City Star came before the learned recovery officer. He heard that applications on many days, and ultimately, by virtue of the last order being impugned on 19th of May, he dismisses it.
The petitioners in both the matters have an excellent case on everything except the merits. Merits, by merits I mean the compromise settlement.
Yes, my lord.
Except for that, you have an excellent case in both the matters.
In law, especially, my lord. On facts, I'm
not merely procedure. Review power is there. That
Yes.
power is a substantive power. So not merely procedure, maybe.
And my lord, if I may add one more thing.
Yes.
This is a glaring instance of something, my lord, which should not happen. 19th of May, he passes an order. But all the orders passed by the learned recovery officers are uploaded in the official website of the Debt Recovery Tribunal. The order stands uploaded on 22nd of May. I have screenshots of 2021 where the order is not found to be uploaded. But on 20th of May, before the order is actually uploaded, sale notice is published in the newspaper. The learned recovery officer has yet not made his mind. He uploads it on 22nd.
No, uploading is the only instance when it is published. I mean, in the sense that like we pass orders in open court formally.
Order
Then
20.
it is,
Order 20, akin to order 20.
if that be so, then that cannot be a deterrent. I mean, if the order is passed formally in open court
My
by
lord.
the recovery officer, then even if it is not uploaded, it may be implemented. Why not?
My lord,
Where is
the
bar?
reason is, my lord,
Yes.
that I have a right to prefer an appeal only within 30 days from the order being passed.
Passed, not uploaded. That is where I am.
My lord, passed will be either that he passes in court.
That was not done here.
Never.
That is what I am asking you. The uploading was the only instance here when it was published.
Yes.
When it became public knowledge.
Yes.
So there was no other instance.
No other mode. And my lord, this is not happening once. Throughout the process, right from the beginning, on and after 14th of November 2022, if my lord takes into consideration, the attachment application was heard. This had been the procedure that our orders are uploaded 10-15 days after the same are passed. And there are many orders. And lastly, my lord, this, even if it is so moto review,
Which is the year 2022 or 23? 1905?
923. My lord, even if it is taken as a review application, so motor review. My lord, this is a review in guise of an appeal. Because the learned recovery officer in 2015 has already passed a reasoned order, very happily worded, on almost all aspects of the matter.
So rather you turn that appeal, availability of appeal to your advantage in a sense.
Yes.
That could have been appealed against the previous one.
Previous one, the bank could have preferred an appeal. Now, my lord, they could not have preferred an appeal. Not possible. Because, my lord, after 30 days, in law, my lord, the Honorable Apex Court has held, no appeal lies before the learned presiding officer under Section 30. So, my lord, an end route is taken in guise of a review. If my lord permits me to place, my lord.
When was this application filed, Mr. Mishra?
My lord, this was moved on 14th of November, as I understand the affidavit.
Here is 1st of August 22. It must be somewhere, I mean, near about that time.
July 2022, as I find at page number 11 of the affidavit portion. My lord, the order of 2015 of the learned recovery officer was amenable to challenge under Section 30, but within 30 days, not thereafter. My lord, that is what the Honorable Apex Court has held. I will not trouble, my lord, it's very clear. Because that right was not available anymore, my lord, they filed this application, have the issue of review open. It's not a suo motu review. And again, had the entire adjudication process been carried out.
Thank you, sir.
Yes, yes. My lord, paragraph 13 is relevant. 2018, volume 2, Supreme Court cases 7 to 5. Le lo. My lord, para 13 is relevant, my lord. After 30 days, the order is sacrosanct. My lord, the res judicata applies.
Res judicata?
In the instant case that order could not have been reopened, this right is now lost to the bank to prefer.
Attained finality is a better expression.
Yeah, it has attained finality.
Res judicata does not apply here.
So,
But
my lord,
even
that
then, I
is my
understand
short point on this. I'm grateful, man.
Thank you, sir. Yes, yes, SBI now.
By mistake, the wrong sale notice has been. Just by way of a supplement.
You are ready with that affidavit, supplement?
Right,
Okay. Very good. Yes.
Same is my situation. I have also annexed the wrong one. I will be very honest. We are sailing on the same boat.
Obviously, we have to.
And my lord, we are coordinating also, and the errors are also coordinately.
Comma, full stop, everything.
Yes, yes. Paragraph prayers
You have
also.
checked up also.
Yeah, prayers also.
My lord, true. I must confess and admit, we
here
are
probably-
together. And therefore, my lord, on
So need
facts.
not be notionally segregated also.
Yes,
here.
my
Need
lord,
not.
we are
You're
together.
actually selling on the same. Very good. Thank you. Yes,
They will
bank.
make submission that there is a collusion between us, but we are together.
No, there is no question about it.
You have to say the same.
You have to. If you did not, there would be collusion. Yes, bank, what else do you have to say apart from what they say?
Very short submission, my lord. Only two aspects have to look into. First is that they have filed this writ petition having a prayer to set aside the order of the learned recovery officer. There is another writ petition pending before the court. That writ petition number is 8899-2023.
That will get consequentially whatever.
And
whatever happens.
there are civil legal applications also pending by the petition number 1.
Either you or they will cite this order there.
So it has to be clubbed together or whatever.
Depending on the outcome.
So this prayer, Malak, can you see the prayer? I do not know where the question of review comes. Admittedly, there was a compromise settlement by and between the parties. There was a default. This default clause says that whenever there is a default in making the not adhering to the terms of the compromise, clock will go back. So the recovery order does the same. So the recovery order passed in order. pass an order saying that you have, since you have made not adhered to the terms and conditions of the settlement terms, so the clock goes back. He attached the property and put it for sale. Firstly, secondly, kindly see the section 30, my lord.
Appeal provision is there.
In there.
That's an admitted position.
So they have to go and appeal. So the alternative remedy is there. Why not they go and appeal? There is no error apparent on the face of this order. At least there is no judicial error. Even he has not he has gone not in the review of the order. He has just adhered to the judgment which has passed by the presiding officer. He did what the PO said. He has not reviewed the order. The PO said that.
Now, Mr. Mishra's point of res judicata becomes important. Now I understand why he said res judicata. I did not understand at that point of time. If it has attained finality, can you reopen that?
No,
you have not even sought for a modification of the recovery officer's order.
No, I do not reopen that. Not even seeking for. I am asking that there was a compromise settlement by and between the parties. The current admitted fact. There is a default clause. It is an admitted fact. The default clause says if you do not adhere to the terms and conditions of the settlement, whatever the terms and conditions are, it will go back.
That exercise was that option was once exercised before the recovery officer. The recovery officer held against you in the sense that no, the title has passed to the to City Star.
So the recovery officer passed an order.
Can
saying
you reopen that order again by the recovery officer himself? Can it be reopened? And that too on your application, which seeks for a modification of the presiding officer's certificate.
Let us not go by this application. I do not know where this application comes from.
The order itself was passed on this application.
Maybe
Then the order is utterly without jurisdiction. There is no reason why suo motu it should be exercised.
Maybe this application may be another application. I do not know. This is not the part of the record. I do not know where this application comes from. There may be another application also. I do not know. I do not find this in the record.
Then the supplement. Then I'll issue rule of 340 against both of them.
Yes.
Satisfy yourself on this. Ask your client. Your agent must be here. Somebody must be watching who is appearing in the.
I must be written. I must take instruction from my client. This application is that application or some other application because there is no number.
Some of your officers must be here. SBI watches. If not your other side, you.
No. Madam, understand that
what was the application for? Give me a copy of the application on which the order was passed. An application has been recorded in the order itself. An application was there.
Can you see the order?
Show me that application. It's your application.
Can you see this order, madam?
Very good.
This order on page 74.
This is.
I am not disputing that this may not be the application. I am only saying this may not also. Well, can you see the order also? Well, can you see this order? Page 74.
If I accept your positive assertion of may,
well, can you see page 74?
Because that option is also there. If it is that may, if I take positively, then it is that application. If that be so, then you don't have a case. You are admitting that.
Well, can you see the order once? Page 74.
Yes, 74.
This is the order which. No, not 124. The order which they have challenged. Sorry.
Now that is the order in question. That was passed on this application.
This order, my lord.
No, they are saying on this application, this order was passed.
This page
the recall application.
Page 15.
Page 74 order.
No, page 15.
Oh, November 22 order was passed on the strength
of
this
I'm sorry.
application.
Yes, right.
And thereafter, my lord, the City Star intervened, sought to.
This was the earlier order.
This was the earlier.
Earlier order. So now the order under challenge is on page 119, perhaps. Page P15. Yes, same prayer.
Yes.
The prayer B says, setting aside the order dated 19th May 2023.
This is which one? I'm sorry, I'm probably on the wrong writ petition.
No, it says page 15. My annexer.
This is WPA, which one?
4.
13 WPA number?
13667.
13667. Page number 124.
Yes.
This order is not passed based upon this application.
They're challenging several orders.
Yes.
Sorry, page 89 is the order on 218 which continues to 124 and is the final order. Kindly see 89.
Page 89 is the parent order
That's
under challenge.
Kindly see the prayer, my lord. Let us go by prayer.
record 5218 and 89.
Kindly see the prayer, my lord. Page 42. Prayer B. A writ and or of in nature of the statutory do issue internally questioning and or setting aside the order dated 19th May 2023. And sale notice dated 20th May. Just next annexure. So 19th May 2023 is on page 124.
I'll give them that liberty to
My lord,
modify.
Nah, I must go out of
Totally
that.
bad order. Bad order not on merits. Merits, you have a very good case, as I said. This is one
For
of the
them
few
only.
cases where you have a good case on merits, but they have a much better case on the jurisdiction issue. And 226 is primarily on jurisdiction in as much as your matter is concerned.
So my lord, this order is not the modification of the certificate.
Very well. So you are saying they have
Then
not even challenged 141122 order.
No, not at all.
Argue on 226 power of court.
My lord, my lord,
Argue on that. What are the what are the fetters? Because that has been shown to me. I cannot shut my eyes on that.
my lord, express my
I'm
lord's
not
mind, my lord,
biased against the bank. Why should I be? My money is also lying in the state bank.
my lord, that.
And I'll also suffer
So
from it.
in that case, I
But if you have passed an order without jurisdiction, let me suffer.
where is that order, my lord? That is what my limited understanding says. It's not that order.
14th November 2022, unless that order was there, could the 2023 order be passed?
So it is their fault. It is not my fault.
So very well. 2023, you say that this application, the 2023 order was not passed on this application.
Correct.
Definitely not.
Not.
No.
So it is not under challenge.
Then the rest goes.
This goes.
Very well. That is your argument. Anything else?
Unless appeal provision is there, my lord. I know what my lord is.
Passing through my mind, I am very open in what is passing through my mind, so that you can answer.
So I did not answer any question, my lord.
Then don't.
My lord put in my
Accept
lord.
arguments.
My lord put in my arguments also in that order. My lord, express my lord's view. That's all.
No, I'll have to. Obvious. So and I'll record your argument also that this supplementary affidavit, this application was not the basis of the import order.
And most importantly, when there is a provision of review, it is not this order at least, this order is not a jurisdictional error. The order under challenge is not a jurisdictional order. There is a provision for review in the statute. This cannot be.
Achha, let us once see the 2023 order before we part with the matter. Just once.
Order under challenge.
The order actually under challenge.
Yes, 19th May. Very well.
That is page 119, you said?
124 in serial number 4. Item number 4.
124.
Mr. Dotto's petition.
No, I'll check. This is the order dated 19th of May 23.
I'm grateful. I'm deeply.
Right. What is this order? Let's just once check up before parting with it.
Yes. May I read?
Read the relevant portion, Mr.
Let us go good, bad, indifferent, whatever it may be.
Cannot be three together.
It is not beyond jurisdiction.
Either of the three. Either good or bad or indifferent. Let us see
Mine
whether
is-
it's indifferent or not. So very well. Yes. So page 127, the prayer has been referred to.
And
Last
page-
sentence. Page 127, the last sentence, please come there.
Yes.
Hence, he prays for allowing his intervening application. So this was an
Intervening
intervention.
city stars application. Who is the lead petitioner here?
Acha.
And then can you see page 128, last paragraph?
All right. So you say this order cannot be called into question. Very well.
So
Yes.
they are agreed with,
Maybe agreed, but they have not
like,
challenged.
they are agreed with the last paragraph 130. Can you see? The sale notice is directed to be published in a newspaper or whatever sale proclamation has been issued. So they are agreed with this only. This is within his power. It's not a judicial error at all. And there is a provision of appeal. 30 is there. Now, why did not they go in appeal? Can you see that also?
Yes.
Can you see that also? Why did not they go in appeal? Either the Swan Automobiles, who is the borrower mortgager, or the city star.
City, yes.
Kindly see
Yes.
page 30. Appeal against the order of recovery officer.
Mm-hmm.
Section 30. Notwithstanding anything contained in section 29, any person means city star also, aggrieved by an order of recovery officer made under this act may, within 30 days from the date on which a copy of the order is issued to him, prefer an appeal to the tribunal. Second, on receipt on appeal under subsection 1, the tribunal may, after giving an opportunity to the appellant to be heard and after making such inquiry as it deems fit, confirm, modify, or set aside the order made by so and so, so and so. Now, page section 30A. This is the most important. 30A. Deposit of amount of debt due for filing an appeal against the order. So, when an appeal is preferred against any order of recovery of under section 30 by any person from whom the amount debt is due to bank or financial institution or consortium banks, appeal shall not be entertained by tribunal unless such person has deposited with the tribunal 50% of the amount of debt due to the tribunal.
And one other aspect is also there, which is implicit. City Star has filed the second writ petition, because they could only file a writ petition against that or any challenge against that, because they did not come into the picture before that.
Right.
It's their intervention application which has been rejected.
Much before.
Much before?
Much before this order.
No, the second writ petition, the writ petition preferred by City Star is virtually on the against the order passed on their intervention application. It starts with that.
No. I may be corrected. I stand corrected.
No, intervention application
Of SREC India Limited. My learned friend appearing for the SREC India Limited, he intervened that I am having a right in that property. The respondent number,
It was his intervention application.
respondent number 3.
Oh, City Star was there previously also.
Yes.
That is not a
Long back.
right.
These are all my learned friend may conclude. He is for SREC India Limited.
Anything to add?
Add some judgments.
Anything to add? Comma, add.
Yes.
Yes.
Not only to add some points, before giving that, my way, give that background of the matter only within 2 minutes, my lord.
I'll take that background after 10 minutes. I'll come back.
Very
in 10
well.
minutes.
वही से बोलो ना।
Yes, please. Continue.
Well, may I? तो थोड़ा हटो। My lord, entire property in dispute is, my lord, 1 vigha, 1 kattha, 1 chitak, 9 square feet. Separate in 4 title deeds. 2 title deeds lying with my clients, Asrec India Limited, respond number 3, as mortgage. 2 properties, my lord, my City Star, now City Star, and my lord 1. Let me say the owner of that 4 properties. Owner of the properties, Asrec India Limited, hold Kusum Bagaria shares and Joyশ্রী Bagaria shares. And SBI today claim Shaunak Bagaria and Jyoti Prakash Bagaria shares. And City Star submits today, they are claiming, they don't know what they are claiming today, because I will show from the agreement which has not been submitted. It is submitted with a writ petition but not been read with your lordship. Now my lord will please come to the agreement, what agreement made with City Star and Shaunak Bagaria. Sorry,
You are placing from the
my lord,
which one?
at first I am taking my lord WPA 1367, my lord, item number 4.
Right.
My lord, please come to the agreement.
Pages.
Page 52. Agreement made between my lord Sohon Automobiles Private Limited, page number 54.
Yes.
And my lord City Star Infrastructure Limited.
Right.
My lord, who is Sohon Automobiles Private Limited against the property of my lord Shaunak Bagaria and Jyoti Prakash Bagaria.
Yes, Sean from Shaunak. Yes.
But
Yes, yes.
owner of the property is Shaunak Bagaria and Jyoti Prakash Bagaria. Now, my lord, very interestingly, please come to the schedule of that agreement. Page number 58. Alleged mortgage property secured assets. All that piece and parcel of property situated at 25 Rakhaldas Addi Road, Kolkata 700027. Property belongs to me. 2 part, half. 1 part, mortgage with the SBI. Dispute coming arise later on. Property mortgage 1 part with that State Bank of India. 1 part not mortgage with anybody else, but the now recovery officer attached that property being the personal property of the certificate debtors. So neither the borrower, they are not at all the owner. One Swan Automobiles has made an agreement with that. The writ petitioner here.
This predated all these agreements.
Yes, long date. This agreement after my lord that mortgaging the property to Asrec as well as the State Bank of India. Not naturally, my lord, they are asking for return back my money or my lord that property. They are after releasing the mortgage. They are claim against the SBI.
So were you a party ever to these proceedings?
They are certificate debtors are party in this proceeding.
You?
Yes, my lord, I am this party. No, he not in agreement.
No, in these parties before the tribunal or the recovery.
Yes.
You are party there.
Yes, man.
What was your stand there?
My lord, may I have 2/4 shares. I have made an application, intervening application. That's my learned friend submitted. My intervening application is disposed of. My lord, where I have submitted, see, here is a 4 part of the property. 1, 2, 3, 4. 1/4, 1/4, 1/4, 4 title deed.
Your intervention application was dismissed.
Dismissed, but the property belongs to me as on date. Entire
You
property.
have not preferred any challenge against this order.
No, I am not preferring because, sir, please. I have not required to challenge. I have taken a separate surface action against my half property. Inadvertently, they have annexed that property here also. today my learned friend has submitted that inadvertently that copy has not to be added here, so supplementary affidavit. I am not required to challenge that order. Why? My protection is there because I am expensing my lord, security from 2017, entire property to me. I have taken physical possession under the order of the District Tribunal 1, presiding officer. Property belongs to me, keys with the land receiver. Never that city infrastructure come with me and say, you see, this is my property, so you cannot take the physical possession of the property. Not challenge. All are afterthought, my lord.
You obtained physical possession when?
My lord, 2000 exact date, my lord. Give me that in. My lord, 25th February 2017. Today, my lord, 2023. No application before the PO or my lord
That
challenging.
physical possession was taken in pursuance of an award.
Order of the presiding officer. District Tribunal 1. This matter is pending before the District Tribunal 2. My lord, let me give that. They are that, my lord, that petitioner in item number 3 is, my lord, habitual defaulter. There is a 3 bank loan, my lord. One in from SBI, 13.90 crores claim. From ASREC, 9.61 crores as on date. And my lord, another one is Bank of India, my lord. From there later it can be justified, my lord. Please come to the page number 73. Their own admission, my lord. My lord, last 2 line. Subject to mortgage of bank, my lord, sorry, first paragraph, last 2 line.
This is
Yes, my lord.
13667.
My lord. Page number 73.
72. Yes.
My lord, we have delivered khas vacant
72 or 73?
73, my lord.
3.
First paragraph, last 4 lines. We have delivered khas vacant peaceful and physical possession of the said property subject to mortgage of bank, these State Bank of India, United Bank of India, and Bank of India to the company as per the terms and conditions mentioned in the above memorandum of understanding. So my lord, my claim against that United Bank of India, my lord, assigned to me, I am today ASREC India Limited. So there is a 3 banks. My lord, claim of the SBI is 13.90 crores without interest. My claim is, my lord, 9 crores. And my lord, we don't know the claim of the Bank of India. So
you are claiming to Bank of India?
I am now, my lord, United Bank of India. So my lord, whatever the agreement.
You are on a virtually similar footing as the State Bank of India.
Yes, man.
Earlier, you came in earlier.
Yes.
2017. No, this agreement was of 2010.
2010.
Anyway, virtually on a similar footing.
My lord, so my lord, agreement made between Sonak and my lord, that petitioner, where they are not the party, where the entire property is made agreement. Although 2 parties with me. Well, agreement itself, unregistered agreement.
But as far as this order is concerned, in this matter, in these writ petitions, you don't have any say directly. Whatever the outcome of this will be dependent on the whatever proceedings you have taken out.
No, my lord, I am some more submission, my lord. Let me finish, my. No, my lord, today your lordship is pleased to see the prayer. My learned friend also shows same things. I will not want to repeat it. There is wrong, my lord. Prayer, my lord, please to come the prayer first. What is the prayer made?
Yes. Prayer.
Prayer, my lord, prayer, page number 42. The order dated setting aside the order dated 19th May 2023 and sale notice dated 20th May 2023 being P15 and P16. Now, my lord, will please turn the page and come to the P15. In page 119. My lord, here, my lord, order challenging on 19th May 2023, but here prayer says about the challenging order annexer P15, which says, my lord, 30th January 2023. My lord, wrong. Now, my lord, count to the page P16. P16 says, my lord, the sale notice dated 20th May 2023. which is, my lord, page number 122. 122.
One to two is a coordinate bench order.
Unless and until, my lord,
No, even if the state bank wins this matter, you are not benefited in any way.
yeah, my lord, I will be.
How are you?
Because, my lord, a recovery officer has pleased to say that if because we are holding the physical possession of the entire property. Security guard expenses given till the year of 2017. Recovery officer told that I will decide that security expenses if the property at all sell.
Acha, if it is released from the City Star, then you have a claim. Your claim is revived.
Yes.
Otherwise, if it goes to City Star, your claim is gone.
No, my lord, not only that also. My lord, City Star claim is also protected by the land recovery officer. My lord, will please see the orders first.
Let us come to that.
Come to, my lord, page number 131 of the impugned order, although it is wrong in the prayer.
Oh, 131, yes.
My lord, last paragraph. Although decree has not been issued by the Honorable Presiding Officer ASREC India Limited, it cannot be denied that recovery of public money is also involved in the said original application. Hence, percentage of distribution of sale proceeds of the personal properties of CDs between the CHB and ASREC India Limited will be decided at a later stage in case the sale materialize. In such case, City Star Infrastructure Limited is also at liberty to pray for refund CHB on behalf of cities by pray for refund of their principal amount of rupees 1.05 crore paid by them to CHB on behalf of the cities by making proper application along with original title deed of cities before the bench before the distribution of the sale proceeds. Now, my lord will please to come. What is the value of the property? Today, before your lordships, my lord, we are fighting each other. What is the value of the 50%? My lord, 50%? No doubt. Neither, my lord, neither senior friend of that, my lord, petitioner number 1 in, my lord, that item number 4 or, my lord, 3 is not demanding my property here in Reed Court. My lord, half property is mine self. Mortgage with me, I have taken the surface action. Now, my lord, value of the property, my lord, will please to come that order itself. In page
That
number
is why
one,
I'm not understanding how you are affected either. Your 50% remains.
my lord, 50% and the share, my lord, just now I have read it.
Yes.
My lord, may I read again, my lord?
Or if the order goes, the entire thing goes. That necessarily does not go. Even if the previous order is revived, suppose they win, the petitioners win, then also your right does not go automatically.
Well, my right under the Surface Act, there is
there, already there. What is
50%. But here, share is, my lord, just now I have read. My lord, and recovery says you have given a huge cost of that, my lord, security. Today also I am paying the huge cost. Nobody asks for City Star or what. All are afterthought, my lord, very designed not to sell the property by the recovery officer, my lord. Now, my lord will please to come. This is, my lord, preliminary property, preliminary, my lord, my point about the writ petition. Now, my lord, I am asking myself, have the right of the petitioner to money lend under the Bengal Money Laundering Act 1940? My lord, Act says no, my lord. My lord, section 8, my lord. Not a single document has been produced before this writ court as well as that, my lord, that debt recovery tribunal that they can money lend under the Bengal Money Lending Act 1940.
এটা ফেরত দিও। Yes.
Sorry, thank you. My lord, another thing is, my lord, supplementary affidavit file, my learned friend. My lord, please to come that default clause of that. Although the entire documents has not been given again, only one page given of that compromise letter. My lord, page number 10.
Yes. 10.
My lord, default clause, in case, my lord, last but one paragraph, my lord, under tick mark.
In case.
In case the compromise amount is not paid as per the above arrangements from the date of communication of sanction, all right and remedies available to the bank prior to the compromise settlement will be availed to the bank again. This includes the right to collect from the company and the guarantors and the entire amount due and the compromise settlement together with interest.
This was there in the compromise settlement certificate also.
Yes.
Yes.
So if that right has already been, they have not paid, only that amount has been paid, entire amount we, after given that single or second installment, the entire amount has not been paid, my lord. So, my lord, only my respectful submission is that RO was passed a elaborate order, my lord, against that, my lord, City Star as well as ASIC. Why he has not accepted that? My lord, against that, my lord, and with a proper ground, why he is not accepted. My lord, only that is the appealable order under section 30 of the, my lord, Recovery of Debts and Bankruptcy Act, my lord. My lord, by relying that, my lord, may I put, my lord, only, my lord, that alternative remedy, my lord, by relying that, my lord, I am relying two judgment of Supreme Court, my lord. One is very renowned judgment, 2010 8 SCC, paragraph number 44 and 55. Paragraph number 44 and 55. 2010 8 SCC 110. Para 44 and 55. My lord, this is the 2008 judgment, my lord, today to 2023, my lord. This judgment passed on 17th April 2023 by the Honorable Supreme Court, my lord. My lord, may I read that paragraph 44? My lord, page 1 to 3.
Yes.
My lord, while expressing the aforesaid view, we are conscious that the power conferred upon the High Court under Article 226 of a Constitution of issue to any person or authority, including the appropriate case, any government directors, orders, or writ, including the 5 prerogative writs for the enforcement of any of the right conferred by Part 3 of the any other purpose, are very wide, and there is no express limitation of the exercise of that power. But at the same time, we cannot be oblivious of the rules and self-imposed restraint evolved by this court, which every high court is bound to keep in view while exercising power under 226 of Constitution. My lord,
So Tavati Tandon is very settled.
my lord, paragraph 55, I am not reading it.
No,
It is not readable at all.
Why not? Yes.
Because, my lord, so many words has, my lord.
No, read it out.
No, my lord. My lord, now, my lord, I am relying very well. My lord. It is a matter of serious concern that despite repeated pronouncement of this court, the high courts continue to ignore the availability of statutory remedies under DRT Act and the SABYASACHI Act and exercise jurisdiction under Article 226 for passing orders, which have serious adverse impact on the right of banks and the other financial institutions to recover their dues. We hope and trust that in future the high courts will exercise their discretion in such matters which greater caution, care, and circumspection. Now, my lord, I am relying the judgment of my lord passed by the Honorable Supreme Apex Court on my lord 17th April 2023. My lord, 2023 SCC online SC 435.
Yes.
My lord, paragraph number 13. Well, I am relying 13, 14, and 18. Well, 13 in, sorry, my lord.
13 years.
In view of the fair stand taken by the learned senior counsel appearing for the appellants, we do not wish to interfere with the impugned order passed. We may, however, reiterate and settle position if law on the interference of the High Court invoking Article 226 of the Constitution of India in commercial matters, my lord. It is very important for myself, my lord. Commercial matters, where an effective and efficacious alternative forum has been constituted through a statute, we are also constrained to take judicial notice of the fact that certain high courts continue to interfere in such matter, leading to a regular supply.
This is regarding commercial court sector.
No, my lord, this is also the settlement matter. My lord, interfere by the court. Then my lord, Supreme Court has given this.
So same principle applies.
Yes.
Very.
Now, my lord will please to come paragraph that Satyavati Tendon also relied here, my lord, paragraph number 45, 55 in page number.
Yes.
Not paginated of the judgment,
Did
my
not
lord.
give me the paragraph. 13, 14 and 18 you said paragraphs.
My lord, just you know. No, my lord, Satyavati Tendon judgment has also here noted. I am not reading that. Now, my lord will please to come at paragraph number 14. A writ.
Yes, 14.
A writ of certiorari is to be issued over a decision when the court finds that the process does not conform to the law of statute. In other words, courts are not expected to substitute themselves with the decision-making authority while finding fault with the process along with the reasons assigned. Such a writ is not expected to be issued to remedy all violation. When a tribunal is constituted, it is expected to go into the issue of the fact and law, including the statutory violation. A question as to whether such a violation would be over a mandatory prescription as against the discretionary one of the primarily within the domain of the tribunal. So, my lord, now my lord will please the findings of that, my lord, paragraph number 18. While doing so, we are conscious of the fact that the power conferred under Article 220 of the Constitution of India are rather wide, but are required to be exercised only on extraordinary circumstances is matter pertaining to proceedings and adjudicatory scheme qua a statute. More so, the commercial matters involving a lender and a borrower. Commercial matter, lender and a borrower, when the legislature has provided for a specific mechanism for appropriate redressal. My lord, generally a specially was non-derogant, my lord. When there is a special act, that is my lord, special statutes that have to be followed, my lord. So, my lord, when in that my lord, item number 3, the writ petitioner is a borrower, he has no right without going to challenging that my lord, that order of the landed recovery officer before the landed presiding officer by paying the 50% of the dues of the claim, my lord. Because to protecting the court, my lord, legislation has part, my learned friend has, Mr. Mishra has submitted before your lordship that Supreme Court has passed an order, my lord, pass an judgment that a order against the recovery officer within 30 days means 30 days have to be filed. Otherwise, that my lord, appeal should not be. My lord, so for protecting that my lord, recovery officer order, my lord, only the available remedies, my lord, before the learned presiding officer under section 30 and 30A by depositing that 50% of the claim as on that date, my lord. Here also, my lord, recently Supreme Court also passed a judgment. Previously, my lord, claim amount to be calculated from the date of demand notice. My lord, nowadays, my lord, recent judgment passed by the Honorable Supreme Court that amount to be calculated as on date when the matter on board. 50% amount to be deposited. So, my lord, my humble submission before this Honorable Court that the writ petition of that, my lord, item number 4 doesn't stand because that money lending, Bengal Money Lending Act clearly says that they cannot lend the money without that, my lord, that license from the government authority. So, number one, and their interest has already been protected by that, my lord. So, my lord, one thing I forget to show by my lord submitting another. My lord, value of the property is mentioned in that, my lord. page number 130. By fighting mala all of are against that property which if at all sell, what money will be recovered. Mala page number 130, paragraph number 3. As per valuation report submitted by CHB on such and such, the realizable value of the entire property means my lord half property also. Entire property has been assessed as 5 crores 10 lakh 30,000 only, and as per the valuation report submitted by ASREC India Limited, the realizable value of the entire property has been assessed on 5 crores 1 lakh 82,200. Hence, I am fixing the average value of half of two valuation reports, that is rupees 2 crore 53 lakh 3,550 only as reserve price of half portion of the property being. So, my lord, against that, my lord, page number, next page, last paragraph, 1 crore 5 lakh. My lord, protected for my learned friend, client, 1 crore 5 lakh. So, we are fighting for only 1 crore and my lord, odd figure by the both the my lord ASREC India Limited as well as State Bank of India, being the personal property of that my lord. Against the claim of my lord, more than 25 to 30 crores. My lord, I rest my case.
Yes. Mr. Pandey, you have to add anything? No, Mr. Panda, because you wanted to add. What do you, I mean, intervener means?
My lord, I am a tenant in respect of the 25 Rakhaldas Addi Road, which is going to be sold, my lord. Now, what has happened, my lord? There was an injunction order from this honorable court much prior to this in 2000, and that is continuing. The first appeal, the paper book is ready, and there has been an injunction not to dispossess me. I got the notice in 2023 January. I immediately went there. I said, I am going to produce the documents. I was not allowed a chance, and I was declared an illegal occupant. Now, if the sale is there, I would be affected. And only one thing, my lord, they are talking about the Rakhaldas Addi by 4 deeds. 4 deeds are all undemarcated shares. So they don't have a demarcated share. How they will go for half the share without me? That is also a question. So, and it is, the auction is on 30th.
You were inducted when? As
More than 70 years. I'm still carrying on a garage there, my lord. Around 20 persons work there. Situation is such, my lord, if I am not protected, I will have no chance, my lord. The recovery officer is saying that I have been already declared an illegal occupant there, in spite of showing all the documents by way of affidavit. He is saying that no documents have been shown. The recovery officer is not listening to me.
Recovery officer has not passed any order on your.
He has passed an order stating that I have been declared an illegal occupant.
Have you challenged that order?
My lord, I have to prefer one essay, surface application there.
Have you preferred that?
I will prefer, my lord. This I have come to know, and I have seen.
Whatever happens here, you'll automatically be subject to
that. Will there, but injunction order is there by this honorable court, division bench. So I was praying for an observation so that I can go and I can seek my relief there, and my rights are protected. This is what I am praying, my lord, at this moment.
You took out an application for intervention before the recovery officer.
I have made one interim interlocutory application, my lord, before the recovery officer, asking to recall his order in view of the fact that the Honorable High Court has already passed an order, and the tenancy receipts, I have all produced those by way of an affidavit, but those were not recorded. Again, I have made an application which is being filed today also. So this is the situation, my lord. And on 30th, if it is sold, I have no right. Everything, the police comes and drags me out. I'm grateful.
Mr. Panda, I'll not allow your intervention application, but I'll put in
I understand.
Some observation.
I'm grateful.
Yes, Mr. Dotto, any reply to Money Lenders Act argument and the other arguments?
My lord, so far as my arguments are concerned, your lordship has noted it, my lord, that what is the status of the bank today and what is the jurisdiction of the the recovery officer. On that, I don't think, my lord, much is required to be said in reply.
What about the fact that you have not challenged since 2022, you have not challenged the first order?
No.
Page
These are, my lord, in the same proceeding. In fact, my lord, there is another repetition pending before this honorable court, in respect of which, my lord, this order was passed. The matter was simply adjourned,
Have you challenged that the 22 order?
ওই দিকে কি চ্যালেঞ্জ আছে? Just give me a moment. আছে 30th January I'm told this challenge is under challenge.
Then
Yes.
you have never challenged the 2022 order. Only when this 2023 order is passed, you are challenging, coming up in this challenge.
My lord, if I have finally come against the final order.
But the final order is not, the initial order does not merge in the final order. Final order is a consequential order.
My lord, here, my lord, the final order, my lord, is supposed to merge with whatever interim
No,
orders
but
have
if the 2022 order remains, Mr. Dotto, then that is the parent order. That becomes the parent order. This order is a consequence of that.
Yes.
So why do you say the tribunal was,
Yes.
the recovery officer did not have the jurisdiction to pass this?
My lord,
22 order remains, the jurisdiction is there.
My lord, may I say this, my lord, if the initial order is without jurisdiction, please consider this, but whatever has developed from those, it will all go. But if the recovery officer did not have jurisdiction at that point of time, he does not have jurisdiction today even. Please consider this in that manner.
So are you saying that that order was void ab initio or void
Yes,
being
my lord, my lord,
on a much higher footing then?
could I say this, my lord, inherent lack of jurisdiction and error of jurisdiction. If I am right in my understanding, then my lord, it is an inherent lack of jurisdiction.
And what about Bengal Moneylenders Act?
My lord, so far as Bengal Moneylenders Act, my lord, I do not know why this point has been taken in this proceeding, at least before the writ court. My lord, my transaction may be a void transaction. Let us look into that from that angle. How does it revive the right of the bank apropos the mortgage which has ceased to exist? Please consider this from that point of view.
No, this was argued by ASERC.
Yes. Now,
Half of the property they are arguing has not been touched even.
my lord, please have a look to my lord, page 120. Now, please have a look to my lord, page 127. Or I skip over 127, my lord, since your lordship has heard us enough. Please take 128.
Yes, Mr. Dotto.
Fifth line from the top, half undivided share of the property comprising of 2 title deeds, 1/4 in the name of Kusum Bagaria and Messrs. Joyce Shah are admittedly mortgaged to asset. Another 1/4 share in the name of Shonak Bagaria was mortgaged with CHB. Remaining 1/4 of the undivided share in the property is in the name of Mr. Jyoti Prakash Bagaria. No records could be produced by the assessor KMC on the basis of which renumbered as the files were not traceable, being for more than 10 years old. The property is unlikely to be sold in case they are put on auction separately, as they are not clearly demarcated and identified. But how is this got to, my lord, connected, my lord, with the original compromise certificate to be recalled or nullified? Then, hence, for the sake of recovery of public money, the entire property was attached on the basis of affidavit and prayer made by essay. It is admitted fact that the entire property of 25 so-and-so is under physical possession of the learned receiver appointed by the Honorable Presiding Officer as per the prayer of essay. In some other proceeding, they are paying for the expenses, etc. Now, this cannot be a ground. But again, my lord, the recovery officer, going by the statute, does not enjoy any inherent power. Public money, public interest, more price would be achieved. Inherent power, again, your lordships have held, my lord, has to be saved. Both the Criminal Procedure Code and the Civil Procedure Code has provisions to save inherent powers. This is also missing. Therefore, my lord, anything, my lord, under the sky cannot come, but no matter how much attractive the point may be, for the recovery officer to exercise jurisdiction. And my lord, the judgments, my lord, none of the judgments say that writ court's powers are closed. These are self-imposed restrictions. These can be, I mean, the power can be exercised in extraordinary situations also. Please consider, my lord, whether in the facts of this case, my lord, your lordship can consider this to be an extraordinary case.
What is the interim order prayed for by you?
But for the present, my
Take-
lord, kindly defer the sale proceedings, my lord.
What is the next step to be taken in the sale proceeding?
My
By?
lord, here,
The property.
When? It has been
30th
fixed
30th June.
30th June.
number on the money lenders act, my lord, since I had
Yes,
very,
yes.
short time to take the boita din. Lordship,
Oh, sorry.
but I require a license. No, there can be no dispute on that. Please have a look towards section 13
Or to
of the Bengal Money Lenders Act.
Bengal Money Lenders Act. মনে রাখো। Section
13, 8, read with 13. 8 is clear, my lord. I cannot lend without license. Nothing to say on that. Please have a look to 13. No court shall pass a decree or order in favor of a money lender in any suit instituted by a money lender for recovery of a loan advanced after the date notified under section 8 in any suit instituted by the money lender for the enforcement of an agreement entered into or security taken or for the recovery of any security given in respect of such loan, unless the court is satisfied that at the time or times when the loan or in part thereof was advanced, the money lender held an effective license. Well, any suit of mine may not be maintainable. So, my lord, I lose a right of recovery in a case I have, my lord, advance money without a license.
Great. ওদেরটা ফেরত দিয়ে দাও, হ্যাঁ এটা আনিয়ে দাও, আনিয়ে এর সঙ্গে দিয়ে দেবে, এটাও দিয়ে দেবে, এটা এর সঙ্গে দিয়ে দেবে। Yes, do you want to add anything? Anybody? Mr. Mishra, yes.
May I take your lordship?
Yes, Mr.
My lord, in response to the bank submission, essentially bank says kindly see the prayer in the writ petition.
Yes.
And it confines only to the last order of 19th of May 2023. He says that the order passed, which is palpably without jurisdiction, inherent lack of jurisdiction passed on 14th of November cannot be looked into. That is essentially what he said. Now, my lord, that submission possibly is not correct. Why? My lord, I have handed over the bank's petition, IA number 218 of 2022, which Mr. Mukherjee said that he has to take instruction whether this is their petition or it is not. May I very humbly beseech my lord to kindly take the prayer made in that petition. My lord, my bone of contention, very respectfully, my lord, is that the order of 14th November and the order of 19th May all originate from this application. And this is still not disposed. Kindly take up, my lord, this petition, which is IA number 218 of 2022. This is the handwritten service copy by the bank. Kindly take page number 9. Prayer portion, my lord, modify the certificate dated such and such for a sum of such and such, lack of jurisdiction. Kindly see prayer number C, direct attachment and sale of the mortgage property mentioned. Cost, incidental prayers. Now, may I beseech my lord to kindly take up the order which was passed on 14th of November. In as much as my lord is looking into item number 4, City Stars writ petition, page 89, if I may request, my lord. Yes. After recording the names of the party, my lord will kindly find it the word today.
Today.
Today is date fixed for final hearing of the interim application bearing RC 218 of 2022 And my lord, kindly consider, this is without jurisdiction. And my lord, after res judicata, and kindly see, it doesn't disposes that petition. And my lord, finally, in now 19th of May, kindly consider the order that is under challenge. That is why, my lord, this is merger. My lord, the last page of the impugned order. No, my lord. What's the second last page? Second last page. My lord, page 129. 130. My lord, page 130. Last paragraph.
129.
130, my lord.
130.
130.
Yes. Last paragraph.
My lord, may I read it? But
Yes.
not 3 paragraphs in the bottom. The auction will be conducted online through e-mode procedure. This order allows the prayer made in IA number 218. So, my lord, patent illegality commenced on the basis of the petition which formed the part of order of 14th November passed without jurisdiction, while that aspect was already decided in 2015, to which bank doesn't have any answer. SREC doesn't have any answer. And my lord, this ultimately culminated into the sale order. And that is under challenge.
That order has that application has not yet been formally.
Not yet been disposed. Erroneous submission, my lord. This is one. Secondly, very briefly, my lord, Mr. Kormakar's submission. He is appearing on behalf of SREC. SREC in this proceeding is a non-suitor. SREC has no debt. And the SREC's debt is still to be adjudicated by the learned tribunal. This is the matter before Debts Recovery Tribunal 2. The learned recovery officer is DRT 2. SREC's claim is by virtue of a Section 19 application filed under the Recovery of Debts Act before DRT 1. That suit is still pending. Surfacey action, my lord, crystallization has not happened. I have challenged the security also. My Section 17 is well within the limitation, my lord. I prepared and I filed it. I am intending to file it, my lord. Now, my lord, DRT 1's matter, which is not yet adjudicated, is taken into cognizance by the recovery officer of a DRT 2, where ISPEC is not the certificate holder bank, intervenes and he's been allowed to make all these submissions. Well, this again shows that the orders are without jurisdiction.
Mr. Mishra, please file short written notes of argument.
I will do so, my lord.
Very short written notes of argument, just the points. You will also have to do that.
I'll do so, my lord. And only one judgment with in counter to my lord Satyavati Tandon's and all authorities shown. Satyavati Tandon also says that the rate courts ordinarily will not entertain otherwise. Well, it's very clear. My lord, if I may rely upon, my lord.
Don't have to give copies of the documents you have already cited, because those are already on record. Just the citation and your points in a nutshell.
Yes, my lord.
It may be 1 page, 2 page also, just the points in a nutshell. I don't want a formal, thing.
Very well, my lord.
Just, I have my notes, but even then to collate those, just please file.
My lord, Godrej Sara Limited.
No cited in new judgment now.
My lord, in counter to the judgment which my learned friend has cited on Satyavati Tandon.
Jurisdiction.
Yes, it's entirely on jurisdiction. It considers Titagar, it considers Whirlpool Skate, it considers almost all the authorities and summarizes
What is this? Which judgment?
Malad, this is Godrej Sara Lee Limited versus the Excise and Taxation Officer, Assessing Officer. His Lordship Honorable Justice Dipankar Datta passes an order on 1st of February 2023, 3-bench judgment, Supreme Court. Very clear on this.
Satyavati Tandon was discussed here.
Satyavati Tandon, possibly not.
Not possible.
But my lord, Satyavati Tandon is in my favor. Anyway, my lord will consider it. I am on the point
If
of,
Satyavati Tandon is not considered, then why should I take it?
my lord, I am on the point of that if an order is without jurisdiction, the head.
No, Satyavati Tandon is a Supreme Court judgment that
Is a
prevails
Supreme
unless that has been discussed here. or
It
interpretation
prevails. It prevails.
will have to be on only on Satyavati Tandon's
My lord,
case.
then Satyavati Tandon doesn't. deal-
Subsequent Supreme Court judgments are there, but several judgments have been considered maybe here. But let us be only on anyway. Since you're citing, cite it. Yes.
This will be aiding to the main cause. My lord, Satyavati Tandon doesn't deal with a situation where the order is palpably past lack of jurisdiction. That Satyavati Tandon doesn't deal with.
Very well. So put in your written notes of argument. How soon can you do the
My lord,
just a
this
nutshell
judgment,
tomorrow?
My lord, I have this judgment, my lord, with me.
Which judge? This
This
judgment.
judgment, yes.
What is your
The
answer to
section, my lord, paragraph 9. Clear why that my lord, alternative remedy is not required, because the authority has passed the order by violating the order of the my lord, tribunal. For that reason, my lord, Honorable Justice Dipankar Datta, please to take out that application under and accepting that the 226 have to be decided that when that law point is there involved there. Well,
Kindly
six, paragraph
see
number 9.
para 9. Para 9 says alternate remedy is there, but if
When?
the order is
Last
passed
two lines
without
only, my lord, to be underlined, my lord. Last two line of that.
Written arguments of counsel are concluded today. Full stop. The matter shall be listed tomorrow under the heading to be mentioned for filing of very brief written notes of arguments, indicating in a nutshell the issues on which the parties have argued. Full stop. This much. I'll close arguments tomorrow formally, and I'll pass my order before 30th. Definitely 2 or 3 days before 30th. I'll try.
I'm so grateful.
Grateful, man.
For appreciative. I'm grateful.
You people are so well prepared. Thank you.
My lord, may I hand over the copy of the order which is passed by this honorable court so that it becomes easier, my lord.
Mr. Pandey, you can also file a 1-page, half-page, just
Certainly.
written notes.
Certainly.
Although, because intervention has been heard, prayer has been heard along with this. So file your written notes. I'll keep it on record
I'll-
so that it's on record.
I shall. I'm grateful.
And you can annex that order with that.
Yes.
Thank you. Nothing but perimeter থাকবে না?
New motion item 5.
Lordship, I am for the petitioner, Lordship. Today I am not prepared, Lordship.
On the prayer of the petitioner, the matter is adjourned and shall be taken up in the next monthly list. Next.
Item 6.
I am for the petition.
Yes. What is the matter, please?
I am filed with revisions.
Service has been affected at all? Service has been affected?
Yes,
Papa?
yes, yes, yes.
You are appearing?
For the state, my lord.
Right.
But in this very nutshell, my lord, the petitioner, my lord, has the own road to go to the PWD road, Middle Road. But what happened at the time of storm, but there are bamboo trees grown up on the land of PWD. Now, this has been fallen to cover the roads. The ingress and egress of the petitioner has already been, my lord, taken. I can see this photograph. So, my lord, I made application before the PWD, before the Panchayat and the police authority to clear this. Unless this is cleared, my lord, I cannot go to the main road. This is the only way from my house to the main road. Ingress and egress has already been, my lord, kindly see this. I cannot, my lord.
You are asking for removal of
only, my lord. This is
yes,
not,
why don't you remove?
My lord, this
No.
is the report sent by the police, my lord.
PWD is a party here.
PWD has.
yes, I made them part.
No report.
You are not appearing for the PWD.
No report has come from the PWD, my lord.
This is only to clear this, my lord. I have no prayer is there.
My lord, before the learned SDEA, my lord, Tilnonagar.
There is another issue.
147, my lord, and all report has been sent to.
My prayer is only to remove this.
Bamboo grown on the private land, my lord, who are the minor relatives of the petitioner.
This is another issue. My PWD, also the PWD. So I am not claiming any right, title, interest over any
Have you given a representation?
Yes.
Where is that?
But this is at page
10.
My lord, I'm giving. This is
13, my lord.
yes, page 12, page 13.
This is to the video and Pradhan.
Video Pradhan, next my executive engineer,
Why did you
PWD.
write to the video and Pradhan? Because if this is a PWD land, why Pradhan?
Because Panchayat may clear up this, because Panchayat area, this is Panchayat area, so I made also application before the Panchayat authority also. So this is the situation, clear this, but I cannot.
Are you are also of the opinion that this is PWD road? No, you say it's a private property.
Yes, my lord.
No, this is the Babu ground on PWD road.
My lord, kindly direct the PWD, my lord, to remove, and if any police assistance is required.
That I'll direct.
Yes,
That I'll direct.
that's my. So I have no
Why
claim.
should the PWD remove? I mean, these are not covered by the forest authorities.
No.
These are only bamboo structures, no
Only,
trees.
no, only bamboo. Only I have shown the photograph, my lord, to your lordship.
Learned counsel,
May be
Yes.
considered by the.
learned counsel for the petitioner contends that in view of certain bamboo trees having fallen
My lord.
on the property of the PWD authorities immediately in front of the house of the petitioner, comma, the petitioner's only access to the main road has been blocked, comma, thereby putting the petitioner to immense difficulty and hardship. For next para, despite representations having been given to all the respondent authorities, comma, no action has been taken by the latter to that effect. Full next parallel and counsel for the state files a police report and submits that certain bamboo trees got uprooted due to storm and are lying on a link road within bracket path. First up, it is also stated in the police report that the said bamboos are growing on the PWD land, which is existent at the entrance link road of the petitioner.
This is the case of the.
First up, next para. It is further stated in the police report that already a petition has been taken out before the SDEM Krishnanagar, Nodia, and in course of inquiry, it could be learned that a land dispute is going on between the petitioner with his relatives and one Manoj Bishwas with his associates since long. Full stop, a case has been registered in that regard. Full stop, next para, be that as it may, comma, despite such private dispute going on between the petitioner and a private party, comma, it cannot be gainsaid that certain bamboo trees growing on the PWD land has fallen on the petitioner's link road, which is blocking the petitioner's ingress and egress in respect of his own property. Full stop. Next para. Whatever may be the outcome of the pending criminal case and or the private dispute between the petitioner and his relatives, comma, it is the incumbent duty of the PWD authorities to immediately remove the bamboo trees, comma, which are blocking the ingress and egress to the petitioner's property. Full stop. Accordingly, arekta line add kore din. Despite service none appears for the respondents apart from the state, full stop, the affidavit of service be kept on record. Full stop. In view of the above observations, WPA 13496 of 2023 is allowed, comma, thereby directing the respondent number 2,
Executive engineer.
that is the executive engineer, comma, Nodia Highway Division, Roman 1, comma, PW within bracket roads, bracket close directorate, comma, district Nodia, to immediately remove the bamboo trees which have fallen from the PWD property to the link road connecting the petitioner's property to the main road immediately, comma, positively within a fortnight from the date of communication of this order to the said authority. Full stop. Next para, the respondent number 2 shall act on the communication of the learned advocate for the petitioner, comma, accompanied by a server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance. Full stop. Such removal shall be done in accordance with law. The police report filed in court today be kept on record. No arrest to cause urgency.
My
Mal,
lord,
give
to
the-
correction, your lordship, my lord, one.
Yes, yes, what?
My lord, the bamboo trees, my lord, grown from the private land, felled on the PWD land.
Police does not have any locus to
My
decide.
lord, my lord.
Item 7.
7.
My lord, in this matter, I am appearing on behalf of the petitioner, my lord. This is the affidavit of service. My lord, it is the electricity matter, my lord.
All served?
All served, my lord. Electricity, private respondent has been served, electricity has been served, police has been served.
Yes. What is the?
My lord,
Yes.
my case is that I have purchased a shop room from the private respondent. Private respondent, my lord, kindly come to annexure P1, that is in page 15. This is the deed by which I have purchased this land. My lord, after purchasing the land, my lord, I have mutated the land in my own name. That is in page number 28, annexure P2. After that, I have applied for a license. My lord, that license is already annexed in P3. My lord, now I have applied for the
License for what?
for business in that shop room, sir.
Right.
My lord, after that, I applied for the electricity connection. My lord, now the private respondent has tried to disturb me, and they have filed two suits. One is my lord, and 124 suit, an application for application under section 144 subclause 2, that is in page 34, where in this suit he has stated me that I am the licensee, so that I have to take the electricity connection without taking the permission from him. This is his allegation. But the fact is that I purchased the shop room. He has suppressed this. And
What is the other proceeding?
my lord, another proceedings that is also annexed here, that is in P8 38. That is a civil suit. Civil court has not granted the injunction.
What do you say?
CAC personnel were there, my lord, twice.
Obstruction did by the.
Obstruction was there, that's why I couldn't.
Despite service, none appears for the private respondents, although the CSC Limited and the petitioner are represented through counsel. First up, the petitioner contends that the petitioner is the owner of the property by purchase and has got the property mutated in the name of the petitioner. First stop, even thereafter, and having obtained a trade license for carrying on a business in the property, when the petitioner applied for an electricity connection in her name, the CSC Limited is not being able to give such connection due to resistance by the private respondent number 8. First up, it is submitted that the private respondent number 8 has initiated a proceeding under section 44 within bracket 2 of the 144 within bracket 2 of the Code of Criminal Procedure against the petitioner. Full stop. That apart, a civil suit has been initiated by the private respondent against the petitioner. Full stop. However, the prayer for ex parte ad interim injunction made by the private respondent stroke plaintiff in the said suit was refused by the civil court. Full stop. A true copy of the said order has also been annexed to the present writ petition. Full stop. Next para. Learned counsel for the CSC Limited submits that the CSC Limited, you held an inspection.
Yes.
That the CSC Limited could not give electricity connection to the petitioner due to resistance by respondent number 8. Next para, it is seen from the materials annexed to the writ petition that the petitioner has proved sufficiently that the petitioner is a settled occupant of the property, having purchased the same and mutated the same in his own name. Next para, since the petitioner also has a trade license and has applied for electricity in due course of law, the resistance by the private respondent number 8 is misconceived in that regard. In any event, the petitioner is entitled under section 43 of the Electricity Act 2003 to have an independent electricity connection at the premises in her own name. Para, accordingly, WPA 13777 of 2023 is allowed on contest, thereby directing the CAC Limited to give new electricity connection to the petitioner at the premises in dispute as expeditiously as possible, comma, positively within a fortnight from within a week from date, full stop.
Kindly make it fortnight.
No, week. You are liable under the law to give within 48 hours.
Subject to compliance other formalities, my lord. You have to.
They have complied. You went to give connection.
Inspection was made, but now whether they have installed the ballot main.
Yes, you have already
Comma, within a week from the date of compliance of all formalities or this order, comma, whichever is later, puts up in the event the CAC personnel are obstructed by the private responder number 8 and or his men and agents, comma, it will be open to the CAC personnel to approach responder number 3, comma, the officer in charge of the Maheshtala police station, who will act on a server copy of this order and give adequate police assistance to the CAC personnel to comply with this order, comma, at the cost of the petitioner. Full stop. In the event any lock or padlock, in the event any padlock or other hindrance is put up by the private respondent, it will be open to the police to remove such padlock for the limited purpose as indicated above. No order is to cause urgency. Thank you. Affidavit of service filed today be kept on record. আগে বলেছি। Thank you.
Item 8.
You are for the
WBSEDC.
Yes.
Connection quotation money has taken, but connection is not
given. Why not given?
My lord, I have just
Please use the microphone.
My lord, I've just received the brief, my lord. I haven't yet I've received it via mail, my lord. As per my instruction, we have received objection from other parties, my lord.
Written objection.
Yes, my lord. But I don't have the copy of the objection
Produce
right
objections tomorrow.
Grateful, my lord.
Learned counsel for the petitioner submits that despite having applied for electricity duly, comma, the WBSEDCL is not giving such connection. First of learned counsel appearing for the distribution licensee submits that although learned counsel has instruction to appear in the matter, comma, the specific written objections purportedly filed by certain objectors in the locality have not been served, had not been handed over to the learned advocate. Full stop. Next para. Accordingly, comma, to enable learned counsel for the WBSEDCL to contest the matter effectively, comma, the matter is adjourned till tomorrow, when learned counsel for the WBSEDCL shall produce copies of the written objections, comma, if any, comma, given by any third parties to the petitioner having new electricity connection. Next. Acha, one thing, you have implemented the state of West Bengal service to Secretary Department of West Bengal. You have not implemented the manager Korimpur customer care center. You have not stated WBSEDCL anywhere. Write it in.
WBSEDCL is effectively not a party, and another thing, my lord.
I'll give him liberty to amend 3.
I think even the officer in charge of the local police station should be made a party.
If they don't make that not fatal, but I'll direct the local police station.
WBCD.
Acha, arekta line add kore liberty is granted to leave is granted to the learned advocate on record for the petitioner to carry out necessary amendment during the course of the day, comma, to the cause title of the writ petition, impleading mentioning the name of the distribution licensee therein. Full stop. In respect of number 3, respond number 3, you have to put in WBSEDCL. At least.
Grateful, my lord.
Thank you.
Two PM matter, item 33 to 39.
Yes.
My lord, may I start with WPA number 13133?
Yes, please.
Now, my lord, two notices, the writ petition has been filed. One is a demand notice of 9th May 2023. And the other one is the disconnection notice of 17th May 2023. Now, my lord, kindly come to page 27, the demand notice.
Yes, please.
Page 27, my lord, 9th May 2023. It is to inform that you were required to submit cash or bank guarantee on account of payment security amounting to rupees such and such as per WBRC regulation after annual review of security deposit calculation, security deposit calculation sheet and bank guarantee format are enclosed herewith. Rest I am not required to, my lord, possibly place. Kindly come to the next page, the calculation sheet. I shall come back to this later on, but for the time being, Lordship will find there are, my lord, 5 columns. First one serial, then bill month, then.
Yes.
The additional security comprises, or my lord, security deposit according to them, comprises of gross amount plus adjustment plus ED plus ED adjustment. This ED is, my lord, electricity duty.
Right.
My lord, it's my specific case that, my lord, till this proposed revision, electricity duty was not included, my lord, in the security deposit. That is one submission. Now, this gross amount, my lord, kindly come to page 36. This is one bill. Now, towards the middle, Lordship will find details of bill, all figures in rupees. It's in, my lord, dark.
Yes, yes, yes.
The box.
Right.
Just under that, my lord, energy charge, peak PF, peak such and such, then demand charge at the rate of rupees such and such per kVA per month, additional demand charge, net demand charge. This is one component. Kindly come to the right. My lord, the extreme right column,
Yes.
difference is here. Just above the gross amount, my lord.
Difference is here. Yes.
This is the other component, my lord. Gross amount consists of intra-line, my lord, demand charges and difference is here. And then, my lord, on the left after this demand charge, Lordship will find WB electricity duty. My lord, this is over and above the gross amount as mentioned in the calculation sheet at page 28. Now, the basis of this security deposit, my lord, in my full submission would appear from, my lord, if your lordship is pleased to take up the act. Section 47.
Yes. 47.
Power to require security. Subject to the provisions of this section, a distribution licensee may require any person who requires a supply of electricity in pursuance of section 43 to give him reasonable security as may be determined by regulation for the payment to him of all monies which may become due to him. My lord, this is important, my lord, become due to him in respect of the electricity supplied to such person, or where any electricity line or electrical plant or electric meter is to be provided for supplying electricity to such person in respect of such and such. And if that person fails to give such security, the distribution licensee may, if he thinks fit, refuse to give the supply, etc. Now kindly come to section 181 once. My lord, power of state commission to make regulation. Now kindly come to subsection 2V.
2B, yes.
Reasonable security payable to the distribution licensee under subsection 1 of section 47. 2V. V for victory.
Yes.
Now,
yes,
on the basis, my lord, the regulation is made. Now kindly come to, my lord, page 82 of the writ petition. My lord. Regulation 52. My lord, kindly come to page 84.
Yes.
Four. Security deposit 4.1. Subject to the provisions of the Act, the distribution licensee may require any person to give security deposit with such licensee for an amount covering 3 months of estimated bills of consumption of electricity. All right, pause here for a moment. It does not say 3 months of estimated bills. Qualifies the bill with consumption of electricity at the prevailing rates. The estimated consumption, not the bill. The estimated consumption shall be based on 12 months consumption of previous period as on 1st April of each year, or estimated consumption based on his application in case of the new applicant. Yep. Then, my lord, new applicant proviso, my lord, I am not going into it.
Yes.
This estimated bill of consumption, my lord, according to me, my lord, cannot include the electricity duty. It's not, my lord, for consumption of electricity. I'll tell you, lordship, why. Because electricity duty, my lord, is sought to be collected on the basis of a separate provision altogether, not under this act or the regulations made there. My lord, kindly may I rely on the Bengal Electricity Duty Act 1935. Kindly come to section 5. Payment of electricity duty. In the case of energy supplied by a licensee, the licensee shall collect and pay to the state government at the prescribed time in the prescribed manner the electricity duty payable under section 3 on the energy supplied by him to the consumer. The duty so payable shall be a first charge on the amount recoverable by the licensee for the energy supplied by him and shall be a date due by him to the state government. Then, provided that the licensee shall not be liable to pay the duty in respect of energy supplied by him for which he has been unable to recover his dues. He is merely, my lord, a collecting agent for the electricity duty to be paid to the state. Now, kindly skip, my lord, section 1A, 5 subsection 1A, kindly come to 2. Where any person fails or neglects to pay at the prescribed time and in the prescribed manner the amount of electricity duty due from him, the licensee of the state government, as the case may be, without prejudice to the right of the state government to recover the amount, under section 8 and after giving not less than 7 clear days notice in writing to such person, cut off the supply of energy to such person and may for that purpose exercise the power conferred on a licensee by subsection 1 of the earlier act for recovery of any charges or sum due in respect of energy supplied by him. So kindly come to section 8 once. Recoveries. Any sum due on account of electricity duty or interest, if not paid at the prescribed time and in the prescribed manner, shall be recoverable as a public demand in the case of energy supplied by a licensee at the discretion of the state government, either from the consumer or subject to the proviso of subsection 1 of section 5 from the licensee. So if not collected, the licensee has no obligation. Then in case of energy supplied by from the consumer, in the case of any other energy from the person liable to pay such duty under subsection 4 or section 5, in the case of interest from the licensee liable to pay such interest under section 5. So my lord, specific provision is there for recovery of the electricity duty, which is not, my lord, part of the consumption of electricity. That is exactly why, my lord, in my full submission, electricity duty, my lord, cannot be included in security deposit. And that is why, my lord, till this year, my lord, never the electricity duty was included. That is my specific case in the pleadings. Yes, my lord. And my lord, that is exactly why, if your lordship is pleased to come to my lord page 81.
Yes.
Which is part of regulation 48, my lord, starting at page 74. Clause 4.16. All statutory levies like electricity duty or any other taxes, duties, cess, etc. imposed by the state government, central government or any other competent authority on sale of electricity shall be extra and shall not be a part of the tariff as determined under these regulations. It's kept separately, not a part of, my lord, the tariff or the consumption. With whether there is notification to copy supply code, তুই দেখিয়ে দিস তাহলে বলবি Now, my lord, in this connection, your lordship would also be pleased to come to section 56.
Yes, other charges are also included. That may be
The
against you.
charges.
So that you have to do. I was thinking of that only.
Yes. I will tell your lordship, my lord.
Yes.
Where any person neglects to pay any charge for electricity or any sum other than a charge for electricity due from him to a licensee. Now here, my lord, the meter and the other charges, my lord, comes in. Or the generating company in respect of supply, transmission, etc. It's not, my lord, other charges. It does not fall, my lord, electricity duty in my submission does not fall within other charges. It's a duty, and my lord, that would appear from, my lord, 4.16 itself, my lord, that it has been segregated.
No, this is regarding where any person neglects to pay any charge for electricity or any sum other than a charge. Now, in section 47, 1B, something else is also included apart from the electricity charges. Electricity line or
That's true.
electrical plant,
Electric line
other
where
things, yes.
I am obliged, my lord.
Charges are also, yes.
Where any electric line or electrical plant or electrical meter is to be provided for supplying electricity to such person in respect of the provision of such line or plant or meter.
In a commercial connection, probably the grid and all, if has to be given for it. But that has no nexus with this.
No.
The duty is all, completely separate.
Completely separate.
So you try to dissociate these 56 other charges from. Very well.
Yes, my lord, in this context, my lord, I kindly come to section 45 once.
Yes.
Power to recover charges. Subject to the provisions of this section, the prices to be charged by a distribution licensee for the supply of electricity by him in pursuance of section 43 shall be in accordance with such tariff fixed from time to time and conditions of his license. The charges for electricity supplied by a distribution licensee shall be fixed in accordance with the method and the principles as may be specified by the concerned state commission, published in such manner so as to give adequate publicity, etc. The charges for electricity supplied by a distribution licensee may include, etc. Then, my lord, that also includes, kindly come to B, a rent or other charges in respect of any electricity meter or electrical plant provided by the distribution license.
Also A, charges for electricity supplied by distribution license.
Yes, that is A.
Fixed
That is
charge in addition, that is demand charges probably. Fixed charge in addition to the charge for the actual electricity supplied.
I'll come to that, my lord. Demand charges is, my lord.
That
the
is
second
another
part.
component of your
Yes.
argument. Very good.
Now, my lord, this is, my lord, my point, my lord, on, my lord, the electricity duty.
Yes.
Now, coming to, my lord, the additional demand charges. Now, kindly come to, my lord, page 74. '74. Kindly come to 75.
Yes, 75.
My lord, clause 4.1, components of tariff.
Right.
The charges for the electricity supplied by a distribution licensee to a consumer shall generally consist of any one or more of the following: fixed charges, demand charges. So tariff includes this.
Yes.
Kindly now, my lord, kindly come to the next page. My lord, clause 4.3.5.
Yes.
Demand charges shall be levied on the basis of maximum demand recorded during the month or 85% of the contract demand, whichever is higher. Then 4.3.6. No demand charges shall be payable by any consumer for the period when load of the consumer is interrupted, totally shed, partially restricted because of any fault of the licensee or its system, or for non-availability of power with the licensee due to lower availability of power from its own generating station and or its other suppliers of power, or imposition of any restriction by the licensee on drawal of power by consumer. However, such exception from demand charge shall not be available if the interruption is caused by grid failure or automatic under frequency relay, tripping, or any force majeure even not related to licensee, or due to disconnection of supply for any fault on the part of the consumer. My lord, forgetting the last part, the other part, my lord, I have definitely not challenged here. But the other part, my lord, still I am liable. Interruption caused by grid failure, I have nothing to do.
No, but the pivot is that they have nothing to do, probably. That is,
But still, I am being
apparently,
penalized.
yes.
I am being
Definitely, you have nothing to do. You may have something to do because you individually may not have something to do.
Absolutely.
But certain problems in user by the users may create the grid failure. And that is one of the main reasons.
That is, my lord,
Overdrawal
one of the grounds in the other reads. But my lord, in any event, I shall make my submission.
Yes, let us forget.
Well, kindly come to page 79.
71.
79.
79, I'm sorry. Yes.
4.10. Notwithstanding anything to the contrary contained anywhere in these regulations, in case where no consumption of energy has taken place, for any reason whatsoever, including disconnection of supply due to fault on the part of the consumer, but excluding instances of interruption in supply due to failure on the part of the licensee, the fixed charge or demand charge of a consumer, as the case may be, shall be calculated on the basis of the contract demand. Now, my lord, kindly come back to (4.3.5).
Yes.
Demand charges shall be levied on the basis of maximum demand recorded during the month or 85% of the contract demand, whichever is higher. And here, my lord, it says shall be calculated on the basis of the contract demand. So 85% goes. Then, my lord, kindly come to the next page. When a licensee bills a consumer for consumption of electricity covering only a part of month caused by discontinuance of consumership before the expiry of a full month, the computation of fixed charges or demand charges shall be made for the entire month, excepting for such consumers under the short-term supply for whom such billing shall be prorated, etc. Now, my lord, these are my obligations under the demand charge. Now, kindly come to, my lord, come back to, my lord, page 28. Yes. Or before, my lord, 28, my lord, I'm sorry, my lord, may I again show, my lord, page 84. Under the regulation, what is the security deposit they can demand? Subject to the page 84, clause 4.1. Yes. Subject to the provisions of the Act, the distribution licensee may require any person to give security deposit with such licensee for an amount covering 3 months of estimated bills of consumption of electricity at the prevailing rate. The estimated consumption shall be based on 12 months consumption of the previous period, as on 1st April of each year, or estimated consumption based on his application in case of new applicant. So 12 months last year, starting from April, from 1st of April, average 3 months. Now kindly come back to page 28. Lordship has seen, my lord, the 12 months recording has been given. Then, my lord, kindly come to the next item. Total gross per MVA from monthly bill is such and such. Is the total of this 12. Then total gross per MVA from monthly bill, same amount. Next, total gross per MVA from other bill. No particulars. No particulars. What is other bill? Then kindly come to C. Average gross per MVA in rupees such and such, A plus B divided by 12. Very well. Then D. CD of current month. Contract demand of current month. 24. Then E. Average monthly gross, C into D. The regulation says 12 months consumption, average 3 months. Where from do they multiply, my lord, with D? That is not the regulation. And in fact, while arriving at the figures above, they have taken into consideration the contract demand. The deficit in whatever it is, whatever amount is payable in terms of the contract demand. So they are here charging twice and multiplied by D. The regulation is very clear. I proceed on the basis that, my lord, they are entitled to electricity duty, to include electricity duty. They are entitled to include, my lord, demand charges. Now, what is the regulation? Regulation says 12 months starting from 1st of April till 31st of March next year, average it, take 3 months average, security deposit. Where from, my lord, in my full submission, firstly, the B is nowhere there. And then in any event, E cannot be there. It's completely contrary to, my lord, the regulation. Cannot be. C, I still understand.
For arriving at this figure, SD value, they have added up these also, C into D and all.
Yes. Yes.
Yes, right. Very good.
C is A plus B. Then D is the current demand. Sorry, C is A plus B divided by 12.
Right, right.
That is valid regulation. Then D comes in.
So A plus B by 12 into 3, that should be then.
Yes, yes. Very well.
Obviously, yes. 3 months.
Yes.
And you are
Yeah, that
saying,
has been done later if SD multiplier.
right.
That has been done later.
It has been done on the entire amount.
Entire amount.
And you have objection regarding other bill also, B also.
Yes, definitely.
What is other bill?
Yes. এই আর কি বলবো? ও আচ্ছা। রাইট। হ্যাঁ, হ্যাঁ। My lord, in this connection, my lord, may I also rely on the regulation 55?
Yes.
Kindly come to 3.2, bill particulars. Three point two point, my lord, page 6.
Bill particulars, yes. 3 point.
Copy আছে extra. Two হাজার 13 regulation. হ্যাঁ রে 3.2.2 2013 regulation 55. কপি নেই? হ্যাঁ দিচ্ছি। আছে রে? Two point two. 3.2 হচ্ছে bill particulars.
Yes.
Lordship got that, my lord. 3.2 bill particulars where the bills are postpaid.
Yes.
Then 3.2.2, the bill shall contain the following minimum details.
Right.
My lord, it does not include, my lord, the electricity duty.
Does not contain the
Electricity duty.
Duty. For electricity duty. First one.
What do you mean by that? I mean, total charges are there. 19, Roman 19. That has to be there.
Very well, my lord.
So
Kindly
that
forget
has
this.
to be
This
the-
is Very complicated. Kindly forget that.
Must be Mr. Chakraborty's brainchild. Assumption is that you have to dispel that.
No, no. Now, my lord, this is, my lord, on the calculation. I particularly, my lord, I am giving emphasis on page 28, my lord, the calculation is completely erroneous. It could not have been multiplied, my lord, by the D.
So ideally, it should be A. Then you take
But
without
ideally,
B.
I would say A divided by 3.
By 12 into 3.
Sorry, by 12 into 3. Yes.
Sorry.
A divided by 12 into 3.
Into 3, yes. Very well.
Now, even, my lord, the disconnection notice which was issued, my lord, kindly come to page 24, 25.
Yes.
Page 25, my lord, this is to inform, or before that, my lord, after subject, kindly come, my lord, DVC email dated 14th April 2023, and then DVC email dated 9th May 2023. Now, my lord, here I annexed, my lord, the email of 9th May 2023, which I placed before your lordship. It's supplementary. Yes. My lord, I missed to annex, my lord, the email of 14th April 2023. May I, my lord, file the supplementary affidavit?
Yes.
14th April 2023 টা লাগাতে হ্যাঁ সার্ভিস করা আছে Now, my lord, kindly come to page 4. Of the supplementary affidavit, and particularly, my lord, the calculation sheet at page 5.
Yes.
My lord, kindly compare page 5 with page 28. The figures are different.
Over. Yes. But the data is for the same period. At the
Yes.
top, 20
April 2022 to March 2023.
Yes, yes, right.
The actual SD required, my lord, in the earlier notice was 23 crores 21 lakh 20,000. Now it has become 26 crore 16 lakhs. The last
23 lakhs, 23 crores.
sorry, কোটি ফোটি আমার মাথায় আসে না, লাখেতেই থাকি আমি। 23 crores 21 lakhs, and my lord, the next notice is 26 crores 16 lakhs. Now kindly come back to page 25. Well, at the penultimate paragraph, as such notice is hereby given, or my lord, this practically the penalty. As such, notice is hereby served on Joy Balaji under section 47(2), read with clause such and such of the regulation 2013 for submission of shortfall amount of security deposit of rupees such and such, the remaining installment amount within 30 days from the date of issuance of this notice. Now, my lord, that is not the law. From the date of receipt. I'll show you, Lordship, my lord. Kindly come to section 47, subsection 2. Where any person has not given such security as is mentioned in subsection 1, or the security given by any person has become invalid or insufficient, the distribution licensee may by notice require that person within 30 days after the service of the notice. So the first day is excluded.
But this was by email, so same date.
After, not from the date.
Achha.
So I lose 1 day. After means, my lord, I ought to have come up with those cases, my lord. After means, my lord, it starts after.
Excludes the date, yes.
And my lord, one additional submission not on merit. In the other matter of Balaji, I have, my lord, prepared a supplementary affidavit. It is service which
Correct. Yes.
39 এর এটা ফাইলটা আছে
Effective language.
এই সেকেন্ডটাতে
13141
আর একটা সাপ্লিমেন্টারি অ্যাফিডেভিট সার্ভিস হয়েছে কালকে সার্ভিস হয়েছে
সাপ্লিমেন্টারি অ্যাফিডেভিট
ইয়েস মাই লর্ড হ্যাঁ হ্যাঁ
আমিও নেই আমরা কেউ নেই তাহলে ওই ম্যাটারটা হতো
My lord, kindly come to page 8. No, no. This is what happened on the last day.
This is binding on me, so I'll follow the same principle of law today also.
I'm sorry, my lord.
This is binding on me, so I'll follow the same principle of law. Ratio laid down in this judge.
Kindly come to the next document, my lord. Page 9.
Some other affidavit in some other some
My lord, I send a mail on the same day
but different.
at 9 p.m. 5 minutes past 9. Yes. Kindly come to the second paragraph. However, phone calls from Mr. Odun Patro, CE commercial from mobile number such and such is being made to the officer of our company, Mr. Anil Kumar Agarwal, at his number such and such, stating that the electricity line would be disconnected by DVC if we do not make payment of differential amount of security deposit by tonight, which is the subject matter of the petition. Kindly turn the page. Page 10, Odun Patro writes back at 11:36 p.m. This has reference to your mail dated such and such at 9:05 p.m. In this context, you were requested to please share ordered direction of the Honorable Kolkata High Court in WPA number 13133 and 13141 pronounced today, that is 16 June 2023, for our necessary action. Further to note that you are required to deposit the shortfall amount of security deposit immediately as per notice served to your good office earlier by DVC, failing which DVC will take necessary action as per provisions of the regulation. Now, my lord, I write again on the next day. Page 11. My lord, third paragraph from the bottom. Kindly take further note that despite the assurance put forward by the learned advocates for Damodar Valley, telephone calls were received from Damodar Valley Corporation on 16 June 2023 threatening disconnection if payment of differential security deposit is not made by the night of 16 June 2023. This is, my lord, addressed to the advocates, to the higher officials also. Next, in the light of the above, you are hereby requested to withdraw your email address to my client dated 16 June 2023 within a period of 1 hour, or else we shall have no other option but to take necessary steps in accordance with law. Then, my lord, kindly come to page 14. After 1 hour, I write again. The second paragraph of the letter, kindly note that more than 1 hour has passed and neither I nor my client has received any intimation with regard to your email dated 16 June as to whether your client is to act contrary to the assurance given to the Honorable High Court. They do not revert back. I pay the money. You pay the money. Because it's a continuous process factory, my lord. I cannot afford to, my lord, shut it down or cause it to be shut down. They know it very well. They know it very well. I really do not know. I was told, my lord, that it's not in the, my lord, the pleadings. But I am told that, my lord, if it is shut down, the blast furnace may burst, causing, my lord, fatal accident. In any event, it's there on record that, my lord, these are continuous factories which cannot be shut down. I had to, and it's note to them. And that is why this arm twisting. Extremely sorry to say, my lord, I am that after the order, this was the stand taken by DVC. Even in the first matter, it may be contended, but that was definitely not the, my lord's identical matters, my lord, 10 matters appearing in the list. One is taken up and, my lord, the whatever it is, the submission is made in the first matter. Naturally, my lord, that continues in the other matters also. I understand two have been disconnected. They could not pay. My lord, those are my submissions. Yes, those are my. Thank you.
My lord, I am hearing, my lord, in only one matter as I was doing on that day, which is WPA number 13133 of 2023. That's, my lord, the.
Yes.
Now, my lord, to start off, my lord, I just, your lordship put a, what I thought, my lord, was a very fair question as to what should be the security deposit according to them. My lord, they went to the extreme right-hand column. My lord, they said A, that's, my lord, 43287927. My lord, divided by 12. And, my lord, into 3. My lord, the figure comes to, my lord, I think, my lord, about 1 crore. And, my lord, the consumption bills are per month, my lord, at times, my lord, 6 crores, 2 crores, or 3 crores, which your lordship will find in the second column. Those are the consumption bills. My lord, that, my lord, is certainly not, my lord, the formula, my lord, which has been, my lord, suggested, my lord, in the Electricity Act. Now, my lord, kindly come to, my lord, we have to, my lord, look at, my lord, section 47 first. That's, my lord, the statutory provision. My lord, form, my lord, requiring, my lord, a security.
So, this is total gross from MVA from monthly bill, Mr. Mukherjee. Now, then, would it suffice if it was A into 3 merely, not by 12? If this was a monthly bill, on the monthly bill,
My lord,
the
it is
yearly.
per, my lord, what we've broken it into is, my lord, per MVA. It's per MVA, the right-hand column. for, my lord, every month per MVA. This was, my lord, megavolt ampere, my lord, which is, my lord, the total bill is, my lord, on the left-hand side. Right. My lord, I have divided, my lord, what is on the left-hand side, my lord, by the contract demand, and, my lord, 10% added to that because they've consumed, my lord, more than, my lord, what they had contracted for. The bills will show that. I'll, my lord, place that. Overdrawal, my lord, has happened. So, my lord, we've added, my lord, 10%. And, my lord, if we don't add 10% and we only take contract demand, then the security deposit will be even higher. I have, my lord, the chart. It would have been in excess of 27 crores. Now, my lord, I must tell your lordships, my lord, 47.2 is, my lord, what is, my lord, important here, along with 1. My lord, kindly have a look at 1, my lord. Subject to the provisions of this section, a distribution licensee may require any person who requires a supply of electricity in pursuance of section 43 to give him, my lord, what is important is reasonable security, as may be determined by regulations. So, my lord, regulations, my lord, are to make, my lord, provision for this. For the payment to him of all monies, and, my lord, this is an important phrase, which may become due to him in respect of the electricity supplied to such person, or where any electric line or electric plant or electric meter is to be provided for supplying electricity to such person in respect of the provision of such line or plant or meter. And if that person fails to give such security, the distribution licensee may, if he thinks fit, refuse to give the supply of electricity or to provide the line, etc. So this is, my lord, at the initial stage, when somebody applies, my lord, for electricity, my lord, I am, my lord, this is what my demand is going to be. You need to lay the lines and supply me electricity, which is why it has A and B. And, my lord, it says, unless they provide reasonable security, there will be, my lord, the licensee can refuse, my lord, to, my lord, supply. Now, my lord, kindly come to subsection 2. Where any person has not given such security as is mentioned in subsection 1. Now, my lord, the second limb, my lord, is important. Or the security given by any person has become invalid or insufficient. So, my lord, by example, my lord, giving, my lord, the two, my lord, situations. If the security, let us say, my lord, is by bank guarantee, or even if it is by cash, my lord, if it's in, my lord, 1,000 rupee notes and there's demonetization, my lord, it's invalid. Similarly, if bank guarantee expires, it's invalid. Or, my lord, the reasonable security, keeping in mind the subsequent events. Now, what can the subsequent events be? Example, my lord, tariff, my lord, refixation. So, my lord, the charges, my lord, are going to go up. Or, my lord, the contract demand goes up. And, my lord, from, say, let us say 12, it becomes 24. Then, my lord, it could also happen, my lord, that there are, my lord, additional, my lord, charges, my lord, which are incurred because of overdrawal. So, my lord, where it becomes insufficient, the distribution licensee may, by notice, require that person within 30 days after the service of the notice to give him reasonable security for the payment of all monies which may become due to him in respect of the supply of electricity or provision of such line or plant or meter. This is, my lord, post, my lord, the supply. While it's going on, my lord, security deposit is already there, and, my lord, it needs to be enhanced. My lord, this is the, now, my lord, 3. If the person referred to in subsection 2 fails to give such security, the distribution licensee may, if he thinks fit, discontinue the supply of electricity for which the period during which the failure continues.
The security is to be given every financial year.
Yes.
Obviously.
Correct.
If during the financial year it enhances,
My lord, it has enhanced in this case, which is the last 12 months. My lord, contract demand has gone up.
Naturally, then it will be.
It has to
who
go.
will apply?
Yes. Now, my lord, on a factual basis, my lord, I've prepared my lord, three things I wanted to rely on. So I've, my lord, prepared, my lord, a compilation. Where is your compile? Now, my lord, kindly have a look at page 102, my lord, which is, this is, my lord, what the facts were.
Yes.
My lord, this is 11th May 2022. My lord, there was, my lord, 10 crores 33 lakhs 50,000 demand, my lord. And the existing, my lord, was 10 crore 58 lakhs 69,344. So, my lord, it got enhanced from the existing 10, my lord, to a further, my lord, 10 crore 33 lakhs 50,000. So it became, my lord, I think 21 odd crores, because your lordship will have a look at the notice, my lord, which has been given. My lord, at page 27, kindly have a look at page 27.
Yes.
9th May, my lord, 2023. This was, my lord, 11th May 2022, a year earlier. Now, my lord, kindly see, it is to intimate that you are required to submit cash or bank guarantee on account of payment security amounting to 26 crores as per WBERC regulation after annual review of security deposit calculation sheet and BG format are enclosed herewith. In view of the above, it is kindly requested to submit the shortfall amount of security. So, my lord, 26 is, my lord, total. They have 21 odd, my lord, there. It's the shortfall amount which is being asked for, either in the form of bank guarantee, for 2 years with a further claim period of so and so. It is also requested to mention, it may please be noted. Now, kindly note this, my lord, penalty, if shortfall security deposit amount is not received, then action may be taken as per provisions of so and so. Then I've quoted, my lord, the regulation, replenishing amount or its installment amount as may be decided will be recovered through energy bill, and no rebate, if any, will be applicable on, my lord, this. Now, the, my lord, the security deposit, my lord, which was lying deposited, was close to 20 crores, 19 crores, 61 lakhs, 20,838. And, my lord, we said now security deposit should be 26 crore, 16 lakh, 5,000. So, my lord, the difference then is, my lord, 6 crores, 54 lakhs, 84,162. So this is what was asked to be made up, my lord, by, my lord, bank guarantee or, my lord, cash, my lord, whatever. Now, my lord, this enhancement calculation now, my lord, has been challenged. Kindly have a look, my lord, at page 28. My lord, the first attack, my lord, is, my lord, to, my lord, saying, my lord, electricity duty has been included, and there is, my lord, no provision, my lord, which, my lord, permits of, my lord, electricity duty, my lord, being included. My lord, this is, my lord, the, my lord, argument. Therefore, electricity duty should not be my lord, form part of the calculation for, my lord, security deposit. Now, my lord, kindly have a look at, my lord, the Bengal Electricity Duty Act 1935 first. And, my lord, kindly see
Yes.
my lord, the purpose of a security deposit is to ensure, my lord, that, my lord, I am not left in the lurch, my lord, after supply of electricity. I have nothing to fall back on. My lord, it has to secure, my lord, a claim, my lord, which I would have, my lord, against, my lord, the person. Now, my lord, kindly have a look at section 5. In the case of energy supplied by a licensee, I'm sorry, my lord, section 5, my lord, I think page 11 of that book.
Yes.
My lord, your lordship had occasion to consider this in Surya alloys, my lord.
Yes, but this is page 6 anyway.
Yes, my lord, section 5, your lordship has that.
Section 5.
Yes.
Yes.
In the case of energy supplied by a licensee, the licensee shall collect and pay to the state government at the prescribed time and in the prescribed manner the electricity duty payable under section 3 on the energy supplied by him to consumers. Now, my lord, the next portion is very, very important because, my lord, it makes me completely liable. The duty so payable shall be a first charge on the amount recoverable by the licensee for the energy supplied by him and shall be a debt due by him to the state government. Now, my lord, the state government levies the duty. Licensee, my lord, is to collect it. But if licensee, my lord, does not recover it and, my lord, make it over to the state government, it's, my lord, a first charge on, my lord, any recovery, my lord, to be made by the licensee and is a debt due, my lord, from the licensee. It's not, my lord, as if, my lord, there's no liability. Now, the next, provided that the licensee shall not be liable to pay the duty in respect of any energy supplied by him for which he has been unable to recover his dues. So, my lord, kindly imagine a situation. My lord, we have, my lord, a bill of, let us say, 1 crore. And, my lord, 15 lakhs, my lord, is, my lord, the duty, my lord, on that. I'm taking hypothetical figures. Now, my lord, that 1 crore I am to get. So, my lord, 1 crore is paid to me, the duty is not paid. My lord, that 1 crore I do not get, 15 lakhs can go and will go because it remains a first charge and it's a debt due by me.
So the language is the duty so payable and not so recovered.
Correct.
The duty so if it was recovered, the duty so recovered shall be a first charge. That wouldn't mean anything.
It says the duty so payable, the amount shall be the first charge on the amount recoverable by the licensee for what? For the energy supply. And shall be a debt due by him to the state government.
Then how do you explain the proviso?
Proviso is if nothing is recovered. Now kindly have a look at 47 again. My lord, may I trouble your lordship, my lord, with 47 again. Kindly see the language. My lord, which may become due to him in respect of the electricity supply. My lord, moment, my lord, there is a supply. My lord, your lordship would recall the line of cases, consumption and supply, my lord, literally, my lord, it's the concept. Yes. Now, my lord, this is in respect of, my lord, energy supply, duty becomes payable. And, my lord, I recover for supply, not the duty I have billed, but what I recover from supply, they take away from me, the state government. Now, I want to show your lordship the contents of a bill. My lord, this is as per regulations. My lord, kindly take the compilation, my lord, which we handed up. My lord, chapter 8, which is pages 98 to 100, my lord.
Yes.
And my lord, at 98, my lord, I've given. My lord, this is 25th April 2011. My lord, the tariff my lord, electricity removal of difficulties, third order.
Yes.
Now, my lord, kindly see. My lord, 8.5. My lord, kindly take page 99.
Yes, 99.
Permissible deviation in monthly energy bill recovery and corresponding payment. The net amount payable for an energy bill after considering taxes, cess, duties, and adjustment of rebates, surcharges, if any, is to be rounded off to the lower value of nearest rupee or any higher multiple up to 10 rupees and the differential amount is to be carried forward for adjustment against net bill on the same principle stated above. However, in case of discontinuance of power purchase agreement or discontinuance as a consumer, the licensee may bill for fractional amount for its dues payable finally. So, my lord, this is included. My lord, all my lord says, etc. in the bill. Now, kindly see 8.5.2. The licensee shall clearly indicate in the consumer's bill following component of tariff and duty: the amount payable in terms of tariff determined by the commission, the amount of state government subsidy if any, fuel and power purchase cost adjustment if any, ad hoc power purchase cost and ad hoc fuel cost and ad hoc generation cost and ad hoc variable cost if any, APR tariff adjustment if any, electricity duty, and the net amount payable. So, my lord, after rebates, after adjustments, my lord, after, my lord, all the additions on the positive side, my lord, and these adjustments, the net amount payable. Kindly have a look at any one of the bills.
No, tariff, insofar as electricity bill payable, the tariff and duty both come in. Undoubtedly, the duty also comes in.
Yes, yes, yes.
But for security deposit purpose, can you add that?
Yes. So,
That-
my lord, my first submission is, my lord, it is in respect of
Yes.
that section 47.
47.
Second, my lord, I am requesting your lordship, my lord, to look at, my lord, section 5. My lord, it's a first charge on any amount recovered. So, moment it is recovered, my lord, it's a dead due. So, if I don't recover the duty, my lord, from what I have, my lord, what I am to receive only and adjust towards my dues, I don't get to do that to the extent of duty. Then, my lord, now kindly have a look at the net bill. My lord, page 36, my lord, kindly have a look.
Yes, 36.
My lord, middle of the page, details of bill.
Details of bill, yes.
Yes. Now, my lord, energy charge, peak rebate, peak surcharge, then, my lord, normal, then off-peak rebate, off-peak surcharge, that's the middle column. Then, my lord, normal PF rebate, normal PF surcharge. Then, my lord, demand charge at the rate of 384 rupees per kVA per month. My lord, then additional energy charge for restricted period, then rental charge, then additional demand charge, net demand charge, etc., etc. Then electricity duty, etc., adjustment. All these, my lord, form. I'm just showing, my lord, that list which was given, where your lordship pointed out, my lord, other charges as well. My lord, which was, my lord.
These are the other charges.
Yes. They're all there. My lord, they all form, my lord, part of the bill. My lord, there cannot be, my lord, a bill for consumption without, my lord, electricity duty. My lord, this is, my lord, the, my lord, position. I don't want to, and my lord, it is, the test is, my lord, reasonable security. And my lord, now, my lord, we are looking at, my lord, what would be reasonable. What should be included, my lord, in the components of a bill, my lord, for, my lord, a security, my lord, deposit amount to be calculated. Now, my lord, kindly have a look at, my lord, the regulations, my lord, my learned friend, my lord, relied on. My lord, which is, my lord, clause 4.1, my lord, at page 82. And this is, my lord, the most important clause, 4.1.
This is regulation notification number 55.
My lord, no, my lord, this is, my lord, 2nd April 2000. My lord, it's an annexure to the writ petition, page 82.
Right.
My lord, regulation 52, my lord.
Yes, yes.
It's notification dated 2nd April. My lord, 55 is the one which had the list.
Yes.
My lord, what would be there?
Right.
My lord, now I'm on 52.
4.1, yes.
Yes. Now kindly have a look at 84, 4.1. Subject to the provisions of the Act, the distribution licensee may require any person to give security deposit with such licensee Now, my lord, what is, my lord, it to cover? For an amount covering 3 months of estimated bills of consumption of electricity at the prevailing rates. And my lord, my respectful submission is, my lord, this has to be interpreted in the light of section 47(1)(a), which is in respect of supply of electricity. That is, my lord, the estimated bills of consumption. And my lord, at the prevailing rates, the estimated consumption. So, my lord, there's 3 months of estimated bills. Now, my lord, what do we multiply 3 with? The estimated consumption shall be based on 12 months consumption of the previous period as on 1st April of each year, or estimated consumption based on his application in case of the new app. So, my lord, previous 12 months, we do an average multiplied by 3. It's 3 months that I have to be covered for. My lord, rough and ready, my lord, that's what it works out.
Let us come to that.
Page 28, my lord.
Page 28,
Yes.
yes.
Now, my lord, kindly.
It is, please just satisfy me on this.
Yes. Now, my lord. My lord, it starts from April. Your lordship seen that?
Yes.
Now, my lord, it goes up to March of the next year.
Hmm.
These were the total consumption bills.
Right,
These included what? The gross amount, etc., my lord. All the entries which I showed your lordships.
Yes,
It
yes.
includes electricity duty, adjustment of any. My lord, it's all there.
Hmm.
This was, my lord, the total bills. Now, my lord, this, my lord, megavolt ampere,
Hmm.
my lord, which is considered,
Hmm.
your lordship will kindly look at, my lord, page, my lord, 36. My lord, I'll explain why that. My lord, this is total. Now, my lord, we are calculating per MVA. My lord, that's megavolt ampere. How do we do that? Now, my lord, contract demand, kindly see page 36 at the top, right-hand side, after bill number, bill date, due date, contract demand. Lordship has that, my lord? Right at the top, page 36.
Oh, yes.
Contract demand, 13,000.
Right.
Now, this is in KVA. Now, my lord, that translates to 13 MVA.
Hmm.
Now, my lord, why don't I take 13?
Hmm.
Because, my lord, additional, my lord, demand charges, my lord, your lordship will find, my lord, at page 36,
Hmm.
that very page, my lord,
Yes, yes.
the details of bill, your lordship has that, my lord?
Yes, yes.
My lord, last 2 entries, additional demand charge, so-and-so,
Hmm.
rebate, so-and-so.
Hmm.
So, my lord, there have been, my lord, additional demand. And, my lord, we have said, we will treat you as within contract demand.
Achha.
My lord, not raise anything, because DVC, my lord, and I'll tell your lordship the basis for this. And this is important. My lord, my lord, I could have said, my lord, charged him, my lord, also, my lord, additional here in the bills and taken the amount up. But I did not. Why? Because, my lord, we allow, my lord, a 10%. A 10%, my lord, overdrawn, additional. So, my lord, it has gone up to 14.3. Now, if my learned friend says that, my lord, you cannot add to contract demand, you please divide by contract demand. Then the security deposit is more. I've done the calculation. So, my lord, it's 14.3. So, what do I get on the right-hand column? Gross per MVA in rupees. This is per MVA, my lord.
Yes, yes.
So, my lord, total gross per MVA from monthly bill is, my lord, 43287927. Total gross per MVA from monthly bill in rupees per MVA, it's the same, is 43287927.
Hmm.
My lord, kindly park B out, my lord, for the time being. B I'll, my lord, deal with later.
Hmm.
Then, my lord, average gross per MVA in rupees MVA. Now, what is that? My lord, kindly, my lord, take out B. It will be A divided by 12.
Hmm.
Because I'm getting per month what it is over a period of 12 months. So, per MVA, I'm calculating, my lord, for each month. My lord, comes to, my lord, the figure 36 would have gone down slightly. My lord, my lord, it would be 36 lakhs, 30,398 or whatever, my lord, that would be the figure. Now, my lord, contract demand of current month.
Hmm.
Now, my lord, Lordship will find, my lord, contract demand has gone up. Your lordship will find it in the last, from the month of December 2022. Kindly look at, my lord, it is 24. And my lord, they have, my lord, actually, my lord, not, my lord, exceeded that, come very close to it, which is what is applied here, 23.428. Lordship has that, my lord? Right at the top, my lord, the left-hand column.
23.42.
Yes, then my lord, 23.478, 23.519, 23.509. Now, my lord, that is, my lord, therefore 20, but the contract demand is 24. So, my lord, what have I done? I have, my lord, what I have calculated, my lord, I have multiplied by contract demand because that is what my obligation is. I have to meet the contract demand.
No, why this multiplication? This I'm not clear on.
My lord, I have got per month, per MVA. Now, my lord, I have to, so my lord, what do I have to supply him? Not 1 MVA. I have to supply him 24.
Oh, so you base it on the contract.
Yes. So, my lord, that's what I've done. And that's the figure I get. Now, my lord, I have to look at 3 months. So I divide that by 3. Multiply that by 3. I multiply that by 3. That's how I get the figure. And my lord, kindly see last year how it was done. Which are my compilation, which are for which there is no objection. My lord, page 102.
Yes.
Kindly see, my lord, this started, of course, from May and went up to, my lord, March 2022. Contract demand was 6 then. Lordship has that in MVA. There was no additional load added. So it remained at 6.
Basis was same.
Same.
This was paid by them.
Yes. And kindly have a look at, my lord, E, average monthly gross, C into D. And D is, my lord, 13. And my lord, 344 is multiplied by 3. Now, my lord, the only 2 additional things here are, my lord, the security deposit. They, my lord, not the electricity duty. Electricity duty.
Yes, duty.
Electricity duty.
And other bill.
Another bill. Now, other bill, my lord, has happened because, my lord, there has been tariff, my lord, revision, my lord, relating back. So, my lord, that is, my lord, the bill which is being given. My lord, that is, of course, subject matter of litigation. But, my lord, it's something which could be payable to me. 47 says, which may become due to him. And that's, my lord, a minuscule amount. My lord, we are not charging it. My lord, we are computing it because your lordship said, my lord, not to, my lord, use that for it. My lord, coercive steps. So we are not charging it, but it's something, my lord, which may become payable. And it's a minuscule amount, my lord, that 3,12,840. Yes, my lord, and divided by 12, my lord, it will come to 20 odd thousand and my lord, 60,000 odd. Nothing. The real, my lord, this thing is, my lord, what in my respectful submission, my lord, remained unexplained, which is, my lord, the basis of, my lord, this. And it can't be 1 crore. My learned friend's calculation was 1 crore. You take the right-hand column, divide by 12, multiply by 3. It doesn't even come to 1 crore because it's per ampere per month, per MVA. And bills I'm showing your lordships go up to 8.5 crores now. Because now the contract demand is more, it's 24. It's an industry which is doing well. And it's not saying, my lord, the grievance is only with regard to the differential. Now, my lord, whatever, so my lord, according to them now, my lord, they should get back, my lord, 19 crores. Because it's only 1 crore, which should be the security deposit. So the balance should be refunded. That's not their case, luckily. Their case is only that this is what you cannot be charging this. I have sufficient. So, my lord, those really are, my lord, my submissions, my lord. My lord, those are my.
Yes, sir.
And my lord, I must tell your lordship one thing. I had made it very clear, my lord, because I wasn't in any other matters. My lord, that assurance of no, my lord, disconnection or. My lord, when the matter happened, I made it very clear that this is the only matter. Your lordship said, ask Mr. Majumdar. He said he is also only in this matter. And your lordship said, very well, it will be only in this matter.
Yes, that conversation took.
Yes, my lord,
And who is appearing for the respondent in the other matter? Have you served in the other matter? So, what is your stand? You cannot adopt anything which Mr. Mukherjee says naturally. It's a different matter. So, anything
my
else?
lord, may I have your lordship's
Yes,
leave?
yes. Apart from that, what else? Make the same submissions.
Yes, my lord.
Make again. You cannot adopt like this. Then you have to engage him also. Engage both of them.
The difficulty is the instructions from the client, my lord.
A message should go to the client then. This is not proper.
And insofar as the, my lord, the other matters, my lord, I am adopting the same submission, my lord. Only with regard to disconnection, my lord, I would say, my lord, there was, my lord, since the assurance was given only in respect of one matter, my lord. I mean, the difficulties, my lord, the consumers are slowly drifting away to the other licensee, overdrawing the power. Even the existing security deposit is unable to cope up with a single monthly bill.
Let us hear. Yes, Mr. Mitra, in reply.
Now, my lord, reasonable security. That has been, my lord.
Original site, my lord, released for the day, my lord.
Hey, no.
Mr. Mitra.
I will reply with you.
No.
No.
At least your matter is not released. Whichever it is. No, Mr. Shah, I'll take up the original matter. At least some can be taken up probably. Mr. Mitra, please be just pinpointed on your.
Let him continue, my lord, for as long as he
Kothay
wants.
jabi?
অনেক জায়গায় যাওয়ার আছে কি করবো?
Yes, sir.
But I may be, my lord, a little, but I'll be here to assist you.
In your matter, Mr. Shah is there. Mr. Mitra, please ensure that he cannot leave the. Physically, you'll have to ensure. Otherwise, I have no other.
He can go to any court. How can I ensure that he's here? The right to.
No, my lord, I shall, my lord, try to be here. I shall try to.
The lordship can request him.
You'll have to face Mr. Mitra otherwise. And I'll also have to face Mr. Mitra.
More daunting, my lord.
So you are more daunting than the court.
Take that as a compliment.
Yes, Mr. Mitra, please. Mr. Shurjin Mitra, yes.
Now, reasonable security, my lord, the law has laid down what the security would be. The regulation. The law says reasonable security. The regulation says this is how you proceed. They of their own, my lord, cannot deviate, my lord. Either they follow it or not at all. They cannot say that at my sweet will, I shall go by MVA, divide it by MVA, total MVA, shall multiply it. No, that cannot be done. Now, ওইটা লাস্টে বলছি। Kindly come to page 28.
28, yes.
Yes. This total amount, this third column, I calculated the total comes to my lord 74 crores 96 lakhs. If I divide it by 12, it comes to 6 crore 24 lakhs. I multiply it with 3, it comes to my lord 18 crore 75 lakhs. My existing security deposit was more than 20 crores.
Acha, Mr. Mitra, what about you did not challenge the previous one, but you paid the same rates were applied, the same yards?
I shall come to that one. I shall come to that.
Yes. They're deviating from the rate stipulated in the statute.
Absolutely. The formula prescribed.
Get your point, yes.
The formula prescribed has not been, my lord, complied with.
Yes, Mr. Mitra, what else?
Yes. Next, my lord, kindly come to my lord, page 102 of the compilation.
Yes.
The duty was not there.
Pardon?
The electricity duty was not there. Only the gross amount. The mode and manner of calculation, my lord, there, in my respectful submission, there cannot be an estoppel here. It did not pinch my client, my lord. They did not also look into it. But, my lord, it appears, my lord, the only object of DVC, my lord, from all the matters which are, some of the matters in which I am there, it appears that the DVC is bent upon, my lord, to see that all the industries go. I can hear, my lord, whatever it is. Now, suddenly 6 crores. I have given the calculation. 18 crores would be required, the security deposit 20 crores. 18 crores including excise, the electricity duty, which has to be, my lord, omitted, which was not there, my lord. They have relied on it. I'm grateful to DVC for relying on this. Now, my lord, next submission is electricity duty. Section 5(1). The proviso, my lord, has been sought to be avoided by saying that if they don't recover anything, kindly come back to 5(1). Section 5(1) along with the proviso, my lord, a harmonious reading would be, my lord, that if they don't recover anything, they are not liable to pay. The first charge would be on the amount which they recover. Otherwise, my lord, this supplement, the proviso would not have been there. It is very clear. If you can't recover, no, nothing. It's not that if nothing can be recovered, only then proviso would come into effect. No. Now, my lord,
Yes, Mr. Mitra, this is all.
Lordship, my lord, kindly, my lord. Oh, compilation in 1928. Now, my lord, the compilation page 98. আমাদের যেটা আমরা যেটা দেখালাম সেটা তো পার্টিকুলার্স অফ বিল তো পড়ে।
হ্যাঁ 2013 is পরে
হ্যাঁ
একটা পরে সাপ্লাই কোড।
That's true. Page 98, 5.2 at page 99 of, my lord, the compilation has been relied on to show that electricity duty is part of the bill. Now, my lord, this is a regulation 48 of 2011, and the regulation I relied on was 2013, the particulars of bills.
Those operate in different fields, probably.
No,
this is tariff. 48 is tariff.
It is supply code section 1500
This is the one they have annexed in the compilation is tariff. Regulatory Commission terms and conditions.
So,
tariff. These are tariff regulations.
Very well. Then it's included in tariff, my lord. Separately, it cannot be done.
Duty is not a same regulation. এখানে tariff
Very
is
well.
outside. এখানে আমরা যেটা দেখালাম 2011 রেগুলেশনে tariff is outside the
Yes, Mr. Mitra, so this is all. Let us stop here. Heard learned counsel for the parties in court today be kept on record. Judgment is reserved in the matter.
মানে
আর কি
টাইম নো অ্যাকশন মানে যদি ওরা আবার ডিসকাউন্ট আজকে অবধি অ্যাসুরেন্স ছিল যদি কালকে
Kishet, oh, in the first matter, my lord, the assurance was till today.
Assurance that they'll not disconnect.
Or, my lord, yes, the oral assurance, my lord.
Don't disconnect before I decide.
Though, my lord, there they said that, my lord, in the first matter, no demand was made, but the first matter also demand was made.
আচ্ছা একটা লাইন অ্যাড করে দিন ওই অর্ডারটাতে সেম অর্ডার থাকবে শুধু একটা লাইন অ্যাড হবে the respondent shall not disconnect the electricity supply on the ground of non-payment of the disputed amount till disposal of the writ petitions. দুটোই হলো সেই
And already, my lord, in two cases, my lord, it has already been disconnected. My
these
lord.
two matters we are in.
And only the first matter, my lord, where the supply has not been disconnected. Only in respect to the
In
first.
these two matters within among these two matters in any matter you have disconnected already.
Yes,
Yes,
no,
two
my lord.
matters they have.
And
In these two we are taking up two matters.
Out of the bunch, my lord.
7 matters have been taken up today.
Oh, now we took up seven matters.
Seven.
I heard 7 matters.
Yes, ma'am.
If not already affected, then I'll put it. যা বললাম তাই comma if not already affected.
My lord, only I was praying in item number 38, I have suffered a disconnection. But I was praying.
No,
My lord, I was,
no intermodal.
because my lord, my difference is 1 crore, but 5 crores is with.
Even then, such a original set.
এগুলো তো ওদের
আচ্ছা প্রদ্যুৎ বাসু কোথায় বাসু নেই এখন কেন আমার তো বলেনি কিছু ঠিক আছে
Malad, before taking original side, Malad,
yes
we have a great flight, Malad, in respect of item 20. My junior was there, Malad. Monday, Sunday, the position will be taken over. The clients have come all the way from Malad district.
what is the item number
28,
28 what
appellate side.
yes what is the urgency you said
The position will be taken over in respect of on Sunday.
28 যেটা আছে কালকে তুমি উপরে 4-5টার মধ্যে দিয়ে দাও অ্যাপেলেট সাইড
Grateful.
very good please inform the other side if
My
possible
lord, I shall give the notice.
My lord, original side may be permitted to mention, my lord.
yes
This is a matter not for inclusion, my lord. The order was passed on Tuesday, my lord. The matter was taken up and heard. This was the order passed, my lord. Order was passed on the basis of a notification that SABYASACHI would be enacted by NBFC upon a claim of 50 lakhs and above, my lord. I have found out a notification, my lord, that says.
file a recall application file a
Madam.
formal application
And I am the writ petitioner, my lord. It has been fixed on 27th, my lord. I am praying to be mentioned, my lord. I will withdraw the writ petition, my lord.
will withdraw the
Nothing will remains in the writ petition, my lord. That is the thing. A notification has been found.
27th come back on 27th and say that
But I have.
your
given-
mistake that's why
Yes, my lord. That is
no,
why.
I acted on the mistake so my mistake also
No, my lord.
just
It
point
was my
this
fault,
out
my lord.
to me on the next occasion I'll remember
Obliged, my lord.
এটা ফেরত দিন
Original side for judgment, item number 1, Sri Dipendra Kumar Sanyal versus the director and members of Secretary Board of Governors.
Accordingly, WPO 1137 of 2023 is allowed on contest, thereby setting aside the impugned decision of the Board of Governors by the resolution adopted by it on May 30th, 2017 and its subsequent confirmations. No address to cost, address certificate copies.
Court applications. Item number 2, Amit Kumar Kejriwal versus RBI and others.
This is my writ petition, my lord.
Written 25th September written. Well, yes. Yes, Ms. Vance.
Yeah, this is my writ petition, my lord. On the last
Writ
occasion.
petition is returnable probably on some other.
I understand, my lord. That's what I was saying. My lord, an order was passed on the last.
Take the microphone. Yes.
An
Order was passed on the last occasion.
on the
Yes.
last occasion, but what my lord was not placed before the lordship, I was not there. There are two aspects, my lord.
Microphone is not functioning. Please help me.
Yes, there were two aspects, my lord. There are
Yes.
two banks orders have been passed, my lord, with respect to respondent number 2, which is the UCO Bank. There is another bank, my lord, Bank of India. Since they were not appearing when the matter was before Justice Bhattacharya and thereafter here, my lord, so no order was passed. But, my lord, I am also, my lord, seeking reliefs, my lord, with respect to respondent number 6 bank, which, my lord, till date, my lord, no order was passed. My lord, may I just explain, my lord? The writ petition, my lord, has been filed on twofold aspect. On the basis of a forensic audit report, my lord, which is inconclusive, and, my lord, which has several red flags, my lord, I was declared willful defaulter by respondent number 2 UCO Bank. Now, my lord, that aspect is separate. With respect to, my lord, Bank of India, respondent number 6, my lord, I was classified, my lord, my account, the company's account was classified as fraud on the basis of that forensic audit report, and, my lord, contrary to RBI master circular pertaining to fraud, classification account of fraud. Today, my lord, there are judgments which, there is a Supreme Court judgment, my lord, which has come up 27 March 23, which says classification, my lord, cannot be done without any hearing or without providing any copy, because it has far-reaching consequences.
Yes.
So my relief, my lord, with respect to respondent number 6 is that today that classification, my lord, has been done. I wasn't even aware of it. Is, my lord, in breach of principles of natural justice?
So could you club the two causes of action together?
Because
the separate causes of action.
my lord, it arises out of that forensic audit report. My lord, I know your lordship.
Genesis may be the same, but this is different. I mean, one is your declaration of willful defaulter, probably in connection with that. That is a separate aspect altogether. And this account classification as fraud, although based on the same document, maybe it's an entirely different cause of action.
My lord, I'll tell your lordship why, my lord, this has been clubbed. Because, my lord, the company today went to NCLT, and, my lord, orders have been passed, is under liquidation, and money has been paid off completely. They were all a part of the same consortium, my lord, when it was happening in NCLT. So today, my lord, everything arises out of that forensic audit report. And I am, my lord, saying that on that basis, let the banks, my lord, not take any steps.
The relief sought is entirely on a different footing. The basis may be the same.
My lord, because the basis is that report, I know your lordship's view is that this court, my lord.
I don't know my view. What is my view?
In another matter, my lord, I was
They say
that forensic audit report, my lord, whether it is reliable, not reliable, or should be looked into.
that is regarding willful defaulter, yes.
Yes.
But fraud, this is a different cause of action altogether.
My lord, also that is on that
I can
document.
give you leave to file another writ petition, although it's not merely technical. It's on a different cause of action against a different entity, different bank.
My lord, also, my lord, with regard to willful default only, my lord.
Willful defaulter, the willful defaulter identification committee under the master circular has done this. Now that is a separate cause of action. Willful defaulter committee and the bank are not same entities.
They are different.
Theoretically, they are different entities.
Yes, but my lord, the petitioner is the same.
Petitioner is the same.
Here, rights of the petitioner.
Petitioner may have several causes of action against different banks on different footings. How do you relate at all? One is a bank is classifying your account as a fraud account.
Yes,
The
my
other
lord.
is willful defaulter identification committee marks you as a willful defaulter on the basis of complaint of a particular bank. Or not even that.
On the basis of
on the basis of certain defaults, basically willful default. Now, willful default and classification as fraud, an account being classified as fraud are different. These are two different entities altogether.
Lord, account was classified, my lord, of the company. Willful default.
Company remains the same.
Today, my lord, I am the promoter who is before your lordship.
Yes.
So, my lord, I am affected, my lord, by the action of these two respondent banks, my lord, which is on the basis of that report. And I say, my lord, if the report is inconclusive, the actions of the bank, my lord, relying on an inconclusive report is arbitrary, unreasonableness, and, my lord, unfair. When a report is placed
Are you challenging the report also?
as well, my lord, I am not challenging. I am saying let
challenge.
not. Yes, I am not challenging. I
To
can
challenge the report, if that was a cause of action, I mean, if that was an order, not a report, then your logic would be perfect, because you are challenging on the basis of the same order, these causes of action emanate. But here it's a document, it's a piece of document on the basis of which two separate actions have been taken by two entities.
by two entities.
Two
The
entities.
petitioner has.
Yes, willful defaulter identification committee is a different entity under the master circular 2015.
Yes, my lord.
And bank is a different entity altogether, and that too, this is a different bank.
Different bank, but
Maybe the document is the same, maybe they are part of the same consortium,
Yes.
but their acts of the act of the Bank of India of marking your account as a fraud account, that's a different component altogether of the cause of action, not the same cause of action. Doesn't arise from the same chain of events. I mean, the document is only same.
Milord, I
They may
understand.
rely on that document, may rely on other documents also.
Milord, I understand what your lordship is saying.
Shall
but
give you
since-
liberty to file another.
Wait, Milord,
it-
that
it-
is one aspect.
Do it tomorrow, day after tomorrow.
I'll do that. But with respect to this, what has already happened, Milord, I'll bow down to that.
What has happened remains.
Yeah, I'll tell you, Lordship. Milord, what has happened is today, Milord, when it was before Justice Motion Bhattacharya, Milord, we said
That is the actual cause of action.
no, she gave me time, Milord, to go 15 days, and then they were supposed to do it in a time-bound manner, Milord. The review
That is his
committee.
connection with the fraud account.
No, with regard to the willful default, 15 days. Then, Milord, they come and say that I cannot now do it within 15 days. There is a reconstitution of the review committee, and I need 6 months. So, Milord, in the meantime,
That submission is not correct, Your Lordship.
yes,
There
it
is
is
5.5
Your
months.
Lordship. So,
5.5 months. Yes, let us proceed.
so, Milord, in that regard, Milord, there must be some, Milord, protection, some stay, because Milord, they are taking the only reason, Milord, I did not press for that stay on that day, Milord, is because they said it will be done by 21st of May. Now, Milord, they come and say that they are going to take 5 and 6 months or whatever my
Possibly, Your
learned
Lordship,
friend
I am
says.
appealing for the respondent number 2, Your Lordship.
Then,
I will indicate, Your Lordship. That is not correct, Your Lordship. On the first day, when they appeared, they pressed for the application. Their main contention was that their representation has not been considered before the review committee because they were out of time. They were out of time by a year. I had given them the chance of making submission before the Lordship will take it up.
No, I'll not take it up. I'll just check.
No, I have not submitted on minutes, Your
Milord,
Lordship.
that order I am referring to.
I was asked whether I will give them a scope of representation before the review committee or not. I said yes. I will take instructions and I will let them.
Yes, and Milord,
There was an order passed that they will be allowed to make a representation before the review committee. Otherwise, they would have lost the forum, Your Lordship.
Milord,
I have never
possible
said
that
6 months time or anything of that sort. After this direction was done, there was a direction upon me to asking the review committee to conclude its decision making by a certain date, which was not possible. That is why I came before Your Lordship and informed Your Lordship that this is the current situation. And even on the last occasion, the learned friend who was appearing on behalf of the petitioners had sought Your Lordship to ask for a stay. Your Lordship was of the opinion that it is not required at this point of time and refused it.
No, that
It
is
was not required. It is there online, Your Lordship. It is live streamed, Your Lordship.
No, that was
It
not.
is live streamed, Your Lordship. Can take it up anytime it wants.
Milord, kindly
Specifically refused this prayer.
Milord, kindly see the order once, 28th April 23. I was given liberty to make the representation by 5th May 23, and the bank shall take a decision by 22nd May 23. Then, Milord, so Milord, in that case, if it was happening within a few days, Milord, no stay was required. Then, Milord, they come on the next day.
Reconsider the UCO Bank. That was on the UCO Bank's sub.
Yes, Your Lordship. I am respondent number 2, appealing for the review bank.
You are for the UCO Bank?
Yes, Your Lordship.
Yes. Milord, 28th April has your Lordship.
What are you asking for in this?
Milord, I am saying now
application?
that
What is the
they
application
want-
for?
Milord, now that they want more time, Milord, I have original writ petition also. I have asked for stay, Milord, of the decision of the willful default. Till such time they take a decision. My preliminary.
What is the stage you come up at?
Milord,
Show cause.
show cause, then Milord, order passed. Thereafter, Milord, I was given liberty. I was beyond time. Milord. Review. So now is the review stage. Review was to be done by 22nd May 23. This is clearly recorded.
Watch, otherwise that willful defaulter declaration remains.
Otherwise, it remains,
The
Milord.
review committee, they say, will be constituted after 6 months.
No, that is not correct, Your Lordship. Lordship has recorded this order.
See, Milord.
1 minute. Review committee, let us see the order first.
Kindly see, Milord.
I'll hear her first. Please take your seat. I'll hear you definitely.
Milord, order of 28th April 2023. Matter has been kept today for respondent bank to take instructions whether the bank is willing to reconsider the grievance of the petitioner and extend the time period for petitioner to approach the review
What is
committee.
the meaning of this? What representation? What reconsideration?
Milord,
What
kindly
was the scope of the reconsideration?
that I will give a representation to the review committee.
All right.
Learned counsel appearing submits it is willing to consider any representation which the petitioner may take before the bank and come to a decision on the same.
You had preferred the writ petition against the identification committee order
Yes.
declaration.
Yes.
Very well. Then this order was passed after
Yes.
that.
Okay, last paragraph, 3 lines. Petitioner liberty to make representation by 5th May. I have done that. I have enclosed. The UCO Bank shall take a decision in the matter by 22nd May 2023.
Right.
Thereafter, my lord, the matter did not appear, my lord. It was just before the vacation. Then, my lord, 5th June, your lordship, the matter had come. Even though my name is recorded there, my lord, I wasn't present. No, my lord.
Take care of that next time. Ask your juniors not to.
It is candidly submitted by learned counsel appearing for the respondent number 2 UCO Bank that in the meantime, there has been a change in the person heading the review committee, due to which the fresh hearing to be given by the review committee has been stalled. That apart, it is contended that the Reserve Bank of India in the meantime has asked the respondent number 2 to hold its hands in the matter, since apparently an amendment of the relevant circular of the RBI is on the anvil pursuant to a judgment of the Supreme Court. As such, learned counsel for the respondent number 2 prays for 3 months adjournment and extension of time to conclude the hearing by the review committee as per direction dated 28 April 23 passed in the present writ petition. In view of the same, matter is adjourned and shall be listed, my lord, September 25, 23. My lord, I am praying today before your lordship, my lord, since it was to be done, my lord, on May. And today, my lord, review committee will.
Well, after this order, then you had to challenge this order, because by this order, it was fixed on, to be listed on September 25th, and they were to do it within 3 months. So what is the change circumstance after this order?
No, my lord, all I'm saying is the change circumstance, my lord, I am today asking for, my lord, that in the meantime, your lordship will grant me some protection, because today this representation that I have given, my lord, review committee will change, where it will change, who will come, my lord, I don't know. I have.
How does it matter? What is the relevance of the change?
Because, my lord,
your documents are there, they'll consider the documents. If there is a change in the review committee, that would be better for you. Otherwise, it might have been the same repetition of that. I mean, ideally, a change of review committee is better, like a change of bench.
Lord, I understand. All this emanates from the fact that, my lord, that forensic audit report point, my lord, I did not press on 28th April only because, my lord, they were supposed to take it up, my lord, within 15 days. Today, my lord, kindly appreciate, my lord. I am not saying that they cannot rely on any evidence in terms of the 2015 master circular. Of course, my lord, they can. And, my lord, they are supposed to give it to me.
No.
No, my lord, the only thing is, the IBBI, my lord, has clearly stated that a forensic audit report, which is inconclusive, which says that the data provided.
Only one change of circumstance after this order, otherwise prefer an appeal. You have no other remedy. I cannot recall my own order unnecessarily unless you show that there is some change of circumstance. I mean, this point was never argued also.
Yeah, I have stated in my petition that it was a mistake.
In your petition, many things are stated.
I have said.
Sometimes you don't argue those.
No, I have said in my petition now, today, GA1.
This petition, yes.
Yes, that, my lord, this should have been argued. It was a mistake of the junior who was, my lord, appearing. My lord, some clarification.
Don't put it on the junior.
I have
Your
not
mistake-
named him, my lord.
Your mistake is that you did not appear on that date then. That is your mistake. His only mistake was to include your name. That was his or her only mistake. I don't recollect who was there.
No,
Whoever.
Kindly appreciate this situation.
That was her or his only mistake. His only mistake.
My lord, I have not named that person, my lord. The only thing is that, my lord, kindly appreciate one thing, my lord. Today, 25th September, the matter is due to come. 3 months they have. In the meantime, my lord, they publish my name. And, my lord, I am also not able to take any, my lord, business
I
steps.
could have disposed of the writ petition also
That is, my lord, your lordship will dispose of the writ.
with the same relief given to you. That this will go, they will consider, the review committee will consider no reconsideration of the this identification as a declaration as a willful defaulter. I'll not reconsider that. I'll not interfere in this writ petition. But yes, review committee will consider within 3 months. That order remains. If you
I
say
understand they should not take any steps, my lord.
no,
That, my
the
lord.
exact order which was passed will remain. I'll dispose of the writ petition. If you say the writ petition itself becomes infractious in that
I
sense,
bow down before.
yes, it does become infractious in a sense. So that was the only relief I gave, I remember.
Yes,
That
your
the
lord.
petition was kept
Yes,
pending.
pending. No, my lord.
So you have a chance before either a change of mind of this bench or some other bench probably,
Yeah,
hopefully within 3 months.
I'm not asking your lordship to change your lordship's mind, or I mean, Lord, I am not asking your lordship to, do something which is beyond your lordship's hands are perhaps not tied. All I'm saying is that, my lord, if the bank has, my lord, proceeded on a document which they shouldn't have, then, my lord, prima facie or, my lord, conclusively, I have shown, my lord, to your lordship that that order could not have been passed. Kindly seize the forensic report. In that case, should not, my lord, that order be stayed till the review committee takes a decision? That's all. My lord, bank may have been right, my lord, if the forensic audit report, my lord, was a conclusive document.
They were directed to file take up the review committee meeting within 3 months and revert back to this court with their report, with their decision.
Initially, it was only 10 days.
Not granted at the inception. Why should it be granted now?
Inception, my lord. My submission is inception. It was not granted because order was passed on 28th April and they were supposed to take a decision by 22nd May.
Yes, but 5th of June, this order was again passed.
Yes, your lordship granted time, my lord, and that is my mistake. I should have come and asked for stay then. Today, my lord, I am before your lordship saying that an order has been passed based on a red flag document. That document, my lord, is not even a material or evidence.
That will be a re-argument of this.
Yes, and so if they will consider that. I will make all that before them. But, my lord, in that case, my lord, till such time, then nobody will be prejudiced, my lord, if the order is stayed or they are stayed from proceeding on the basis of that order. They cannot
Allow this application, Ms. Banerjee, your learned junior who was there will never get another brief. I won't do it. The petitioner makes the present application virtually for a modification of the order dated June 5, 2023. Full stop, next para. It is contended by learned counsel for the petitioner that initially, when the matter was moved before a coordinate bench on April 28, 2023, the premise of the order was that the petitioner would be at liberty to make a representation before the UCO Bank within May 5, 2023, and the UCO Bank should take a decision in the matter by May 22, 2023. Full stop. It was further recorded that since it was submitted that there was already a representation pending before the UCO Bank, the petitioner shall be at liberty of supplementing the representation within the time indicated. Full stop. However, thereafter, on June 5, 2023, it was recorded by this court when the writ petition came up for hearing that the respondent number 2 stroke UCO Bank, had faced a change in the head of the review committee in the meantime, due to which the fresh hearing to be given by the review committee had been stalled. Full stop. That apart, it was contended that the RBI, in the meantime, had asked the respondent number 2 to hold its hands in the matter, since apparently an amendment of the relevant circular of the RBI was on the anvil, pursuant to a judgment of the Supreme Court. Full stop. It was recorded that, as such, learned counsel for the respondent number 2 prayed for 3 months adjournment and extension of time to conclude the hearing by the review committee, as per direction dated April 28, 2023, passed in the writ petition. Full stop. Next para. In view of such prayer, it was recorded, and upon hearing learned counsel for the parties, the matter was adjourned till September 25, 2023. Full stop. Under the changed circumstances, the hearing by the review committee was directed to be positively concluded by September 6, 2023, and the outcome to be intimated in writing to court by respondent number 2 on the next returnable date. Full stop. Learned counsel for the petitioner submits that if the declaration of willful defaulter taken by the willful defaulter identification committee against the petitioner is not stayed in the meantime, the petitioner shall unnecessarily suffer the rigors of the said declaration comma, which virtually renders the relief sought in the writ petition infructuous. Full stop. That apart, comma, it is apprehended by the petitioner in view of the goings on, going s hyphen on, in the respondent number 2 bank in the meantime, comma, that the reconsideration in question may take up to 6 months instead of 3 months. Full stop. It is further submitted that the petitioner is suffering the scenario and ought to be favored with an order of stay. Full stop. Next para. A perusal of the 2 orders passed in the writ petition indicate that the same reliefs as sought now by way of an interim order was available to the petitioner at both the junctures. Full stop. Next para. It is seen from the first order dated April 13, 2023, passed by a coordinate bench, that learned counsel appearing for the petitioner had submitted that the petitioner intended to go through the review committee for a re-look, but was prevented by the window of 15 days, which had long gone. Full stop. In such perspective, comma, the matter was directed to be listed on April 28, 2023 for the bank to take instructions in the matter. Full stop. Next para. Keeping in view the limited context of the first day apostrophe S submission of the petitioner, comma, the order dated April 28, 2023 merely postponed the exercise and kept it on May 22, 2023, comma, by which time the review committee was to take its decision. Full stop. What happened on June 5, 2023 was that the said date was merely extended till September 20, till 3 months after. Full stop. Next para. Taken comprehensively, comma, the stand of the petitioner is vacillating all along. Full stop. The initial stand taken was that the petitioner intended to go through the review committee for a re-look, but was prevented merely by the window of 15 days, which had expired. For subsequently, comma, when the matter was taken up on April 28, 2023, comma, whatever might have been the time span within which the review committee was expected to complete its hearing, comma, no further prayer was made for stay. Full stop. As on June 5, 2023, comma, no such prayer was reiterated as well, comma, it is seen from the orders which are on record in the matter that the petitioner never insisted upon the passing of any such order of stay of operation of the declaration. Full stop. In any event, comma, in view of the fact that the declaration in question by the first committee is always subject to an independent scrutiny by the review committee, comma, the order dated June 5, 2023 sufficiently covers the apprehension of the petitioner. Full stop. In any event, comma, the matter is yet sub judice, and the decision taken in the meantime, as well as the impugned decision of the first committee, would abide by the result of the writ petition. Full stop. Hence, comma, there is no scope of deviating from the order dated June 5, 2023, insofar as there is no change of circumstances between the said date and today, inasmuch as the new prayer made by the petitioner is concerned. Full stop. Hence, comma, GA number 1 of 2023 is dismissed on contest without any orders to cost. The writ petition, comma, however, comma, shall be listed on the next returnable date as directed earlier. Full stop. It is further clarified that nothing in this order shall prejudice either of the parties in the final hearing of the writ petition. Full stop.
Lordship, since affidavits were not called for, I do not admit.
Since affidavits have not been called for, it is deemed that none of the allegations made in the application, that is GA number 1 of 2023, are admitted by the respondent.
With respect to respondent number 6, my lord, your lordship, then
That will be a fresh adjudication on that, Ms. Banerjee.
it fell
That will also, the same logic applies to that also.
it fell from your lordship.
I'm not penalizing you, but I cannot do that now. In law, I cannot do that now. Sorry, Ms. Banerjee.
Then,
Nothing. At that final hearing,
September.
25th September, not September.
Yes.
Precisely 25th September.
If I am not pressing any allegations in this writ petition against respondent number 6, in that event, my lord, your lordship, then
One page application, I'll grant that order. Next matter.
Much obliged.
Item number 3, Inox Air Products Private Limited versus the Director of Industries,
Yes, please.
Government of West Bengal and others.
Yes, Ms. Microphone with a problem.
It was switched off.
Switched off, it is some auto switch off mechanism has been. Yes, please.
A very short legal question arises. There's a state support for industry scheme of 2013. The incentives promised were industrial promotion assistance, annual electricity duty waiver.
This is this MSME units or
No.
general?
So and for electricity duty waiver, there's a separate clause that if I'm a power intensive unit, as defined in another scheme, which had by then been discontinued, then the benefits were different. So I had applied for, I had originally registered in 2017. Then 2019, after I went into commercial production, I applied for final registration. And I sought for this power intensive electricity duty waiver. Now, the stand that they have taken is that that I do not satisfy the applicability clause of the discontinued scheme. I am only required to answer the definition in that scheme, but the applicability clause of that scheme cannot apply under this scheme. The applicability clause says, because that scheme was for incentive to power intensive units, and the state was returning or reimbursing a portion of the total energy cost.
That scheme has been discontinued now.
In 2009, and that was from 2005 to 2009, and our scheme is in 2013. So they merely adopted the definition. Now perhaps this confusion has arisen because it was not stated as a definition. If I can just quickly take my.
Yes, I think that will be better.
Lordship.
The new scheme where they have referred to that.
Lordship. But kindly take that new scheme. It's at page 48. Just to show that.
Yes.
The name, short title at page 48 in the middle. The scheme may be called the West Bengal State Support for Industry Scheme 2013. And if my lords are pleased to see, the state is divided into different areas, page 54.
Yes.
Classification of areas, group A, B, C, D. I am in D. D is where I've been allotted land. I'm not that. Where I'm allotted land, the kind of power that I require, only the DVC can provide. The state machinery, the state infrastructure is not there.
Right.
Now, kindly take the next page, page 55. There's a clause for industrial promotion assistance. I need not trouble my lord in detail with that. Then 7.2 waiver of electricity duty.
Right.
This was a normal provision. An eligible unit with investment under scale 1, provided the unit has obtained all kind of statutory clearance, will be entitled to receive following subsidy on electricity duty subject to para such and such. Now, groups, that is zones, number of years, percentage waiver, ceiling. So this was the normal clause. Now, kindly take the other clause, which is for power intensive unit, page 58. 9.4.
Yes.
Waiver of electricity duty for EOUs, VAT, CST exempted units and power intensive units. 100% export oriented units
units exempted from paying VAT, CST and power intensive units as defined in WP IPS 2005 will be entitled to receive a waiver of electricity duty without any ceiling for the number of years and also a percentage of waiver in terms of subpara 7.2 above, provided that the quantum of waiver of electricity duty itself shall not be more than 100% of fixed capital investment. And then with the last part, however, in such case, benefit of IPA will not be applicable to the power intensive unit. So they gave me this higher benefit, but they said no industrial promotion assistance. Now, kindly take this scheme of 2005. If my lords is pleased to look at page 108.
Yes.
But it starts at 108. The name, my lord, will find at page 110. Short title.
Right.
Where is it? West Bengal Incentive to Power Intensive Industry Scheme 2005. And note at page 114, note under part B.
Part B, yes.
Look, I will first place the portion that I'm relying upon, and then we'll draw my lord's attention to the other part. B 7.0 entitlement for incentive. The state government through its authorized agent will offer incentive in the form of reimbursement from the state government to all new units or expansion of existing units in the districts falling in Group B and Group C areas as defined in the West Bengal Incentive Scheme 2004, drawing power through HT, that is high tension 33 kVA and extra high tension above 33 kV connection having actual monthly maximum demand of 1500 kVA and above on the net energy charged as stated in the monthly electricity bills at the following rates. So this portion of drawing power through HT 33 kV and EHT above 33 kV connection having actual monthly maximum demand of 1500 kVA and above. So this constituted in my humble submission the definition of a power intensive units, because otherwise it is not defined. The scheme was for power intensive units, but the eligibility, the entitlement was based on this kind of power consumption, that I must be consuming this kind of power. Now kindly go to the previous clause, B.6.0 applicability.
Yes.
This B.6.1, this shall be applicable to all large scale new units and also for expansion of existing units on or after the 16 July 2004 drawing power from West Bengal State Electricity Board.
Okay.
The units may be in private sector, cooperative sector, joint sector, as also companies undertakings owned or managed by the state government of West Bengal and who draw power from WBSEB. So this is what they have said, that I am not fulfilling this particular clause because I'm not drawing power from the West Bengal State Electricity Board. But that was a provisional in my humble submission with the applicability of that scheme. The communication which is under challenge note, which was on my application for final registry note at page 260. But that's in volume 2.
Right. 260, yes.
But it says, with reference to the subject, kindly note that your appeal to consider your above unit as power intensive unit cannot be granted as it will violate clause 6.1 of part B of notification WBIPS 2005. So this is the short note question, whether they can really take the applicability clause of that scheme, because I am in group in this group D areas or zone, that the power can only be provided by DVC. Right? And this was something which I had disclosed upfront. Now that scheme, because they were reimbursing a part of the net energy charge. So the government said that, well, if you're giving it to me, then I will return you. So therefore, you must take it from me, buy the power from me. But here, the electricity duty goes to the government, whoever be the supplier of power.
Why are they relying on this previous scheme? I mean, what is the premise of that?
No, that is only because the definition is borrowed in the scheme, that page 58.
So for that.
Entirely that. So it's a pure legal question. Because I am having to continue to pay this particular amount every month, whereas I'm entitled to pay. Page 58.
Oh, very well. Yes, right.
It's simply because of this. And they have also written a very short decision, because
they don't dispute because I gave them a certificate from DVC, which is my supplier,
Huh.
which mentions that I am connected at
And this WBACTCL, this restriction is not there in the new.
it does not specify that I must get power only from.
It is not there.
Okay,
No
so
restriction is there at least.
that's why they refer to that scheme.
Obviously,
If
yes.
it was here, then it would have been.
Yes, that would be better.
Then I would have known. I would have known before I even ventured. So this is actually because of the source of the power, this discrimination has come about. Whereas the duty is going to the government, whoever be the supplier of the power. But this is a short legal question, but I don't think even an affidavit is required.
No, not required. Only this question, interpretation of this.
Yes, ma'am.
Yes.
Lord, we are applying for WBIDC. We're not the primary respondents. Lord.
What is your stand in this?
Lord, we are not the primary respondents. We don't have any specific stand.
They have served
The
upon-
state has been served.
Yes, ma'am. So the affidavit of services.
All have been served.
I'll just check. I'm told legal remembrancer has been served.
Uh-huh.
And all the respondents have been served.
The state has to answer for this probably.
Yes, yes, ma'am.
The state is the main. I'll just put it as to be mentioned day after tomorrow. Please ask your learned junior to give another notice to the state, indicating that this will be listed on as to be mentioned on day after
Monday-
tomorrow.
Monday.
I'll make that in my say that in my order.
Monday.
Monday, I'm sorry. Yes. Act order. Heard learned senior counsel appearing for the petitioner. Full stop. Since a limited question of law is involved for adjudication, comma, affidavits are not directed at this juncture. Full stop. Since none appears to represent the state, comma, which is the main answering party in the which is the main answering respondent in the present dispute, comma, the learned advocate in record for the petitioner is requested to give another notice to the state, comma, by whichever means, comma, indicating that the matter shall be listed on June 26, 2023 under the heading to be mentioned. For passing orders, first up, it is made clear that in the event the state remains unrepresented on the next date as well, comma, ex parte orders may be passed in the absence of the state. First up, the petitioner shall file a receipt of service of notice as directed today on the next date
I'm ready.
It's coming. Thank
you. Item number 4, Bhanwalal Jajodia versus
I appear
State
for
Bank
the
of India. and
petitioner
others.
seeking leave to withdraw this ballot with liberty to file afresh because this is against the order of a review committee. So willful default matter. The
I'll
order
give you
is
liberty to file afresh before a different bench. On the prayer of learned counsel for the prayer of learned counsel for the petitioner, leave is granted to the petitioner to withdraw the writ petition on the ground of technical defects with liberty to sue afresh. Full stop. Accordingly, WPO 1233 of 2023 is dismissed as withdrawn, comma, with liberty to the petitioner to file a fresh writ petition. It will be a writ petition again.
Yes, my lord.
A fresh writ petition on the self-same cause of action.
I'm deeply
No address to cause certain state. Grateful. Thank you.
Item number 5, MK Developers versus Union of India and others.
The respondent number 5 refused the notice. Written as a
Refused notice?
Yes, the government officer, my lord. G. Chief
That is good
Executive.
service, basically.
Yeah, good service.
Yes.
My lord, the issue is this.
So, Banerjee, you are appearing for whom?
My lord, I appear on behalf of the respondent number 1, 2, 3, and 4.
They are the main answering respondents?
All right, all.
No, I'm asking you.
Answering respondent, my lord, respondent number 4. What happened in this matter?
You are representing 4 also?
Yes.
Yes. What
And
happened?
he's actually refused. All right. He's appearing.
I have not refused.
The written is in his.
Respondent number 5.
No, respondent number 4. That is addressed in the Esplanade Chourungi. Chief Engineer, Military Engineering Ordnance Factory. This is 6th Esplanade. Redirected to Fort William, but therefrom it is refused.
You are representing 1 to 4.
Yes, that matter
Let's
is
take
over.
a seat then.
Matter is over.
Yes.
Well, the issue is this, the petitioner is a contractor.
Petitioner is a contract.
Contractor. And at that point of time, in 2017, the contract was allotted from the Hyderabad as the accepting officer of the chief executive engineer at that point of time.
Right,
Now,
right.
now it is in Calcutta from 1st January 2023. Now it is within the jurisdiction of the Calcutta. The point is this, from 2017, thereafter 2 times the extension was granted. And up to 15th RR, 15th RR, they are regularly getting payment. There was no dispute. But subsequently in March 2020, the G changed. And who came to this position, the disturbance started from there. What is the disturbance, Miller? Prior to that, they are raising the point, the material supplied is a substandard and not in accordance with the contract. But prior to that, all payment was made according to the contract was going on. There is no dispute. Actual point is this. Will kindly come to page number 15 first. 15. That is a letter issued from the Pinar engineers. Kindly see the bottom portion right side. Pinar engineer, he is the approved agent of the bottom right side.
Bottom right?
Yes.
Page 15.
15.
I believe it will be left hand side.
Right hand side. From my side to from right side.
This page?
15, Millard.
This is 15.
Annexed P2.
P2, yes. Right side?
Right. No, P2.
You're seeing a mirror image probably. Mr.
There is a letterhead.
Oh, this?
Yes. That is the approved agent.
My fault. Yes.
Yeah, that is their approved agent. That is the letterhead they have mentioned. Kindly see the.
This is actually the letter tail.
Yes, a letter
Anyway,
tail.
yes.
They are the approved agent of this, and they are in the contract that their name is included. They are the because they have to approve their structural ability.
Right.
And it is mentioned to the accepting officer that it is second paragraph kindly. It is confirmed that Messrs. CRB Sales Barasat Road, Wireless Gate, Barakpur, Kolkata, is hereby allotted to fabricate and erection of the building against a contract number such and such, construction of ingot storage shed inside MS Ichhapur on behalf of our company under supervision and technical guidelines by qualified engineer and manpower. That is their agent they have deployed there. And this company is the authorized as per their contract.
You are Mr. CRB?
No, I am the contractor. I have
CRB has allocated to you?
No.
How are you involved?
There is a contract, there is a clause. At the time of execution of the work, there is a 4 persons they have to deploy, but they have to get the guidelines from them for making construction. They are actually professional engineer. They are professional engineer.
The work was allotted to Mr. CRB?
No, I have approached to this for guidance for getting. He referred as an agent. He will supervise me at site. That was accepted. That was approved by the department. Kindly come to page number 18 in respect of this letter. Reference to letter such and such 18.
Yes, 18.
Yes. Approval is hereby accorded to carry out the PEB structural work through the Messrs. Spinner Engineered Building System, that previous one. As per PS clause 15.1 CA work should be executed strictly as per CA provision.
Where does Spinner come in from? I mean, page 15 says Mr. CRB.
No, that is letterhead was used by the Pinner. That is, they have issued this letter. They have issued this letter mentioning the CRB is their agent. On their behalf, they will supervise the activity.
Very well, then.
That is approved. That is approved.
Spinner is approved. Mr. Spinner is approved.
Spinner is approved. Their agent is also approved. They have mentioned in their letter the CRB will supervise the work in their letter. And
approval is only relating to approval is hereby accorded to carry out the PEB structural work through Messrs. Spinner Engineer Building System Limited such and such as per PS clause. Work should be executed strictly as per CA provisions. Nothing is stated regarding Messrs. CRB.
In this letter, in their letter.
In the approval letter.
Yes, in the
there is no
approval letter.
From this letter,
Yes,
there is no approval
that
to
is not
CRB.
mentioned. That is not mentioned.
No, no.
But that letter, you kindly see the letter 29th of December 2017, page number 18.
18 years.
2017.
I'm there only, yes. And looking at that,
yes,
there is no mention of Messrs. CRB.
Yes, that's true. That's true. That, you know, it is true. But later is that letter was on the date of 29th of December 2017.
So they've cancelled ultimately.
No, 2017 to 2020. I am on the basis of this. I am getting payment. The work was going on. About 80% was completed. Then thereafter 2020, the G changed. What happened? That is the main point. That is
This was an honest GE probably.
Yes, yes, yes. That I am page number 26. Page number 26, last two paragraph. 26. That is a 4 pages letter of the petitioner addressing to the chief executive and also addressed to the different authority. We again visited, I am reading out the relevant portion. We again visited the GE Ichapur office on 23rd of March 2021. And again, GE IP FOI Ichapur, Mr. Masood Ali, IDAC, instructed us to verify some test reports from Jadavpur University. We immediately get it done and again paid additional expenses for it. After at this, I, Mathaprasad Pandey, the petitioner hearing, partner of Mr. MK Developers, went to his chamber in the evening around 7 p.m. and again requested him, stating my financial, mental and financial position, and requested by begging him for payment. On this, Mr. Masood Ali was silent for a minute and told me that he will release all the payments in March 2021 and in return ask for bribe of rupees 10 lakhs against it. He also warned me that if I did not do, my contract will get cancelled and the PEB structure will also be rejected. That letter was given to the Ministry of Defense. Then Ministry of Defense sent a letter, that is letter page number 34. Their system is this: only one complaint is insufficient. By way of second letter, they have to confirm it. Yes, I have made the complaint. That is a letter dated 27th of August 2021. Referring to this letter, please refer to your complaint that is addressing to the petitioner. Please refer to your complaint dated 7/7/2021 on the subject received in this ministry or department. As per policy, complaint is required to be confirmed from the complainant that he or she has actually made the complaint. Accordingly, you are requested to confirm within 30 days of issue of this letter to the undersigned that you have sent or not sent the above mentioned complaint. You are also requested to confirm that the above said complaint has been made you and forward supportive documents, if any, available with you. That is that the ministry, that letter was written by the Undersecretary of Ministry of Defense to the petitioner. Thereafter, accordingly, next page 9/9/21, the confirmation letter was given by the petitioner. Yes, I have written this letter against these persons for demanding money. That is mentioned there. Next page, the investigation started. Page number 34. That is letter dated 16th November 2021. Please refer to complaint dated such and such of Mr. Petitioner's name received under Junior DG, DNV, ID, ENC, branch such and such. Further, received dated ADJ, Chennai, letter dated such and such. It is intimated that the undersigned investigating officer, detailed wide HQ ADJ project Chennai, give it later investigation, the complaint at GIP FOI Ichapur will visit the Ichapur during the last week of such and such. You are hereby advised to get ready all documents, CA number such as construction of ingot storage set, Ichapur, MK developer, and also got available to all concerned. That was he actually started investigation in 2020-21. I got stop payment from 2020 because the dispute arose for this purpose. The G, I came to know for this time being, the G is silently not in position or during the investigation is going on against him. Transfer order is passed against him, but so far information is concerned, he is not holding any official position regarding this.
Why was your payment withheld?
That is the point. That is the point.
I mean, your payment has no nexus with this.
That is the point.
This G is dishonest.
In my petition, 3 prayer is there. First prayer is this: after investigation, my prayer is this: call for the report. What is the fate of the investigation? By this.
That is one aspect of
one aspect. Second aspect is my payment should be cleared. And third aspect, one letter has been given for termination that should be stayed by this court until this.
Where is that letter of termination?
No, not termination. The notice. The next page, page number 35. Final notice: why your contract will not be cancelled, not termination. This is a notice in view of the above. I hereby give you this final notice to accelerate the progress of work and amend the CPM chart in consultation of the G. Please note that if the person stated, that means a reminder, if you do not start the work, I am ready to work, but I have to need the money. I have huge amount is blocked there. I cannot be suffer for this corrupted person.
And where have you claimed that money after this complaint? Have you claimed that money
Yes,
from
yes,
them?
yes, that is a several letters, a bunch of letters I have not enclosed, but the relevant letter.
Show me one
Page
only.
number 19, that is the main letter. That is the letter dated 22nd of December 2020, the main letter. That is a main letter. When I have filed my 16th RR. 22nd of December 2020, we hereby submitting 16th RR in respect of the above CS. So please arrange to pay us the 16th RR. That is that after
This is
that
for work already done by you.
80% about 80%.
So how much is withheld?
In
Have you
this
quantified?
bill there is about 40 lakhs like this is
35,28,565. Page 6, ground
Yes.
6.
amount of building outstanding amount 30 lakh amount of rate of building.
And in the prayer portion also. Very good. Yes, this is all, Mr. Dutt.
My prayer is this. First of all, the investigation report should go. I have no aware what actually happened after investigation because they are not giving the copy. And second, my lord, the payment, I am ready to carry out my pending work. That is my prayer.
Yes, Mr. Banerjee.
Lord, subject to Lordship's kind sanction, Lord, against whom the allegation has been leveled initially in the 2021. Lord, he has not been implicated as a party respondent as Lord, in person. He has not been. And Lord, the complaint was lodged by the petitioner. Thereafter, verification was done and the departmental inquiry is going on. Just now, my learned friend has submitted that he has been shifted and probably he has been shifted from the post. Not only that, when the entire head office.
So I'll take a short report from you on that.
Yes, my lord. That
will suffice probably. But what about the non-disbursal of his amounts?
Now, my lord, the issue, if your lordship.
His dues cannot be withheld.
No, I cannot say that it is to be withheld. Now, my lord, the issue cropped up. My lord, in the year 2020, he raised the bill. The bills are lying, my lord, initially the zone which were, my lord, within the determination. Now, my lord, it is shifted in the month of May, my lord, here. Lord, we do not have the entire records because we are just now my learned friend has admitted that.
I am ready to file. Supply the copy.
That is required because the entire record has not come till date.
That is
because
at the point of
zone has.
Chennai.
Yes, it was Chennai. Now, my lord, it has been shifted in the month of May in
Calcutta.
May only.
May. And when we have seen, my lord, the authority has seen that the work is stalled, then he has issued the notice on 23rd May. After assuming that.
Very well. I'll seek a report on the proceedings.
My lord.
You will file that by after 1 week.
My lord, subject to lordship because from Chennai it will come.
No, because somebody will walk and bring it.
No, my lord,
because from Chennai, how much time does it take?
My lord,
a few seconds, split seconds.
No, my lord, one point. The person investigating is from Calcutta.
There is an inquiry committee, and the disciplinary authority is conducting the inquiry. But I cannot say within a 1 week.
The disciplinary committee is sitting there and conducting. This is in Calcutta.
No, my lord, the zone now, my lord, Calcutta, my lord, in the month of May, my lord, it has come.
The inquiry has to be conducted here.
Yes.
So, inquiry.
From Madras, it is being conducted.
Yes, my lord, because when the allegation was raised, at that point of time, my lord, it was within the Chennai.
This person was not posted in at 46 BT Road then.
No. My lord, if your lordship kindly, that is the problem.
Instruct your client.
2 weeks, my lord, I expect 2 weeks.
2 weeks is reasonable. Very well.
Yes.
I'll give it 2 weeks.
2 weeks.
File a report as to the developments
Yes,
regarding the investigation.
And the payment part, my lord, I shall.
Payment
within
plus,
the
please,
report.
please give a report. Yes.
I am ready to file the copy of this report bill also. Again,
That is not required.
Which report?
Official
Final bill.
instruction is
Because the bill is Chennai, he's saying.
Let them assess first. Let give.
Yes, Lord, we will.
The Lord counsel for the petitioner contends that the petitioner has brought a serious allegation against a garrison engineer of the military engineering services, in respect of the Chennai zone, which has now been shifted to the territorial jurisdiction of this court.
Yes.
Full stop. Next para. It is further submitted that the petitioner has been working in the capacity of a contractor for the military engineering services and has done almost 80% of his work. Full stop. Next para. However, despite the petitioner having sought for clearance of his pending bills, for work already done, comma, for quite a long time now, comma, the said amounts are not being disbursed in favor of the petitioner. For sub next para, it is submitted that the petitioner seeks to have a report on the outcome of the inquiry stroke investigation initiated on the basis of the petitioner's complaint, and also a disbursal of the amount due to the petitioner. For sub next para, learned counsel appearing for the respondent authorities submits that due to the recent shift of the zone from Chennai to Kolkata, comma, only in the month of May 2023, comma, the respondents are not yet equipped with the proper instructions in respect of the queries, QERIES, raised. Footstep next para. As such, comma, learned counsel seeks some time to file a report in that regard. Footstep next para. Acceding to such request of the respondents, comma, the matter is adjourned till 22nd, till July 7, 2023, when the petition and when the respondent shall file a report by way of an affidavit by a competent officer, comma, disclosing the current stage and developments in respect of the investigation stroke inquiry conducted by the respondents on the complaint lodged by the petitioner with regard to the then garrison engineer within bracket north bracket closed. The report shall further disclose as to the respondent's version of the amount due to the petitioner, comma, for work done by him pursuant to the contract issued by the respondent authorities to the petitioner. For sub next para, the petitioner, comma, however, comma, shall take immediate steps for resuming work on an urgent basis as asked by the impugned notice dated May 20, 2023 to undertake. For sub next para, however, comma, the respondents shall not give any effect to the impugned notice dated May 20, 2023 by taking any coercive action against the petitioner for non-compliance of the same till August 31, 2023 or until further order, comma, whichever is earlier. First. Our affidavit of service filed today along with
Return envelope.
the envelope be kept on record. Thank you.
Much obliged.
আসুন এখন এখানেই কথা বলুন।